in item number 3, there was an order passed on the last location that an endeavor would be made to dispose it of today because there is an interim order. Now, my lord, the petitioner, I am for the respondent. The petitioner filed an affidavit in reply yesterday. It is not there in the record. So when the item is called, probably they may take time on that job. So that may be called for, my lord. So it is filed by others, my lord. I am calling them. Thank you.
Yes. Huh? Madam, we had adjourned this specifically with the consent of the parties. Okay, when? Day after?
Yes, sir.
On the,
My lord, next Tuesday is not, on next Thursday, my lord. This Thursday, next Thursday.
when do you want?
My Thursday, my lord.
When? Which
Next,
Thursday?
next Thursday, not this Thursday.
On the prayer made by the on the consent of the parties. Come on, leave the matter on 30. Yes. Seven. Yes. You're from whom? You want to find what? Why? When did they file affidavit in the police? Okay, right. Mr. J.M. Goel, counsel for the protection. Is granted. 10 days, 2 weeks time to file affidavit in the file. Leave the matter after 2 weeks.
May I please your lordship prayer for listing? It is an NREGA matter.
New matter?
NREGA matter.
Is it a new matter or an old matter or a semi-old matter? Or what is it?
23 matter.
23 matter. Pending matter.
Yes.
When do you want?
My lord, listing for next week. Another matter, my lord, it pertains to non-payment of contractor bill. It is the second petition. Immediate.
Same day.
Okay.
Yeah, who are you? Mister? Have you taken the consent? No objection. No. On the prayer for adjournment made by Mr. P. Kalita. Your name is not here.
Yeah.
This is Miss Kalita is there, no Mr. Yes, so you are Miss. Yeah. Typographical error. Mr. P. Kalita and counsel for the response number 2 and 3, which is not objected to by Mr. N. Deka. List the matter after. Huh? List the matter after the week.
Also, I'm paying for a victim of I 34 matter that was collection of sub certificate error. Friday,
Okay. On the prayer for adjournment made by Mr. R. Chaudhary for the which respondent? Point number 2. That matters adjourned for 2 weeks. Huh? When? Next week. Okay. Pending matter or regarding? Huh? Stone fashion, license. When do you want? Monday. I think you will take time. Let us finish the list. I mean, let us finish the. No. How long? You see, one thing is that there are some matters which I think we can just finish off. Then just prior to hearing, we'll take up your case. As a intervener. Huh. Intervener, so there no rights of yours are there. We can only hear you. That's all. That's all. Whatever. Then let us finish up the other matters. Otherwise, we all will take time. Yes. Ah. Oh, yours is also a lengthy matter. Give me the contempt. I mean, the writ petition. Item 3. Yes. Yes. What are the facts? Just a minute. I thought today everyone will be glued to the TV. They are not interested in the results. Yes. So your appointment as a handling contractor for 2 years. Respondent number?
No, my lord. 6% to pay. For a few months, it failed to discharge it. And then, every case can for. Tender was floated. You know, to find an engagement.
Yes.
Here, my lord, document C, tip box. Tip box.
Yes.
Real number 1.
Yes.
And link contact that the default. The distance of the defaulting you are therefore the video was the remaining kind of the I gave my bit, the most then my page 22 I said appointment of handling appointment of handling each can for third is the 19 1 year. Then I deposited
1 year, 3 months.
deposited fee of the liquidity to the bank guarantee. Comment to. I comment the book and then my note. At least contract. I have to speak as. What the labor says. After a few months, I got. Then my note. With you party. Apuni peta. Yes, my lord traded. So I had to make my lord deal with it. And about some facts and wagons. I for the time in hours. Very big. I had to make trade for testing. By we did the big amount I the trading handling for the big ticket. And the for proper. Suddenly, in the first week of January, when I visited the new party everywhere, the district manager told me that you are not rotary. We have reappointed the earlier protector who paid.
For January 23,
Yes. And I have nine my note.
verbally informed.
And my note.
Verbally informed by respondent number
And I visited the
first week, but then, no, just a minute. Informed by whom? Informed by whom? Respondent number?
by the district. Division number.
Is he a party here?
Division, yes.
Respondent number 4.
And also my note. For 5 weeks. Another day. But why? I got a my note email,
So this is respondent number 6. Okay. Email. Where is that page?
page 29. Suddenly I was disappointed. On fine. Which mail was? And what party?
Then it December.
What to your
You
visit?
see, Mr. Counsel, again, so your submission and the documents that have been received by you are not in sequence. You said in the first week of January.
No. It was the 13th of.
Hmm.
18. Actually. The first year visited the SS default branch. On 27/12. That is your big to performance. I had been lost. Big figure. If you want that. Me. Another thing. You know, business. You for performance. If you have comprehensive performance, the understanding belongs to the understanding. But that is its for. You are giving up. You paid. It's for. Tender was from.
So who's working now? He's working.
No. Yeah. You are requested. Cookie is given to me, my lord. One of the big. You are requested to give the you can accept. Yeah. First question is,
Where you are? Where does say you are? To perform handling work at depot in the failure. So you are standby.
now my lord, can you see who has it? It requires another depot.
Respondent number 6. My respondent number 5.
Who is he? No reference to any order of approval by the general manager of it. Who allows contact? Without jurisdiction.
So a work was allotted to you by general manager,
Then
and the manager has.
the depot in charge, the authority and jurisdiction matter,
Now that was, then when did you come to this court? On 23 itself. Eight to 23 you came. Now, there was there any stay order or something?
No, my came but there was a stay order clearly state, coming to this, for this if you email order, you don't get it. Fine. One cannot deliver it. Not the observer the site they do, now last week, what? Okay. Now, other is without a if no order was issued, I mean, like no was issued. Plus, as a result of only uncertainty, equity, equity and that kind of clear. That's my lord.
No, where is the, you came by way of this writ petition?
Yes.
Or earlier writ petition? This writ petition. There is a stay order of that.
Yes.
If you know.
Now the document
No, where is the stay order? No, stay order must be in the main case. There are
the interim order.
8 to 10.
23. Let me finish. My brother, take it.
8 to 10.
And you have to take that down. 8 to 23.
The impugn disconnection shall not be. Okay. So you are allowed to continue.
That was not done. And in after this, that is the that 40 content are now clear lordship. First I am reading it. Party.
Of. I've got it.
That POT method is for direct into returnable date. And so, impute disconnection will not be given effect. It's very clear. But the dictionary has been allowed to run that particular draft of the content. So there cannot be more ambiguous order than it. Here, that we, this code direct, that the impute disconnection will not be given. Email.
So the basic now, what is the prayer in the writ petition? That we think should be set aside.
There was, now my lord, some plenty some different.
Anyway, that the contract now is expired, the period expired, now a fresh contract has been given. No, just answer the question. I think fresh contract has been given, but your term is over. Your only grievance now, one is damages which civil suit is there, can be issued. Then, and one is this contempt case. How much? No, you tell me. No, you tell me how much should be appropriate. I need, you see, I need guidance from senior counsels
I am
also.
giving, I am giving,
Yes.
I am giving, because such respect illegal arbitrage what should be allowed to get away by merely saying, I don't know.
I'm sorry.
Technically, first was your time is over. No. There should be some. You are not going, it called upon to declare their exercise illegal and
To cut a long story short, you want that this court should punish that person because there was intentional violation of the order of this court, interim order. Now, what according to you would be the appropriate punishment or penalty that can be imposed upon?
party. I was
So
only after filing the contempt.
then you are allowed to work. No, it is front of me here. It is in front of me. No. So for 30 days, you could not work. Only because of the contempt case, you were given back the work. Correct? Handling. No.
Even after starting the process of contempt, they deliberately didn't allow me to work for another 30.
So how many days were you not allowed to work? 30 days. That's what I'm saying. So for 30 days, you did not work. But thereafter, you started working again.
And their rules stipulate my work.
Okay, now, what do you think is the appropriate penalty that should be given? Supposing this court holds that yes, contempt has been made out.
Then the part of the High Court was, contempt. It is contempt.
We will proceed, but then we have to frame a charge in a way. Yes, Now framing a charge. What do you think should be the appropriate penalty? I'm not going to frame charges just for the sake of framing charges unless I'm going to give a penalty.
Just take this, not like the mistake. For the majesty of the court.
So I'm asking you, please give guidance to the court also. Yeah. You're skirting the issue. No. Leaving that aside. Leaving that aside. Come down to the brass tacks. The reading of the affidavit will be done by the other side.
I suffered.
You suffered for 30 days.
Their content, it needed some allowed. Even if I take it now, time is over. Later, my lord, the rule of law will not prevail. Rule of law will not. They have admitted. They had apology. They have admitted. That's due to misconduct. What can be misconduct, misunderstanding of the order? It's clear and unambiguous order. I don't think what I.
Yes, please read. Yes, please read.
11,
Page.
page 283.
Yes.
In case of a civil contempt, the High Court may determine the matter of charge either on affidavits filed or to such further evidence accepted taken by itself or reported by a subordinate who but direction by it, first argument that the justice of the case. Having regard to the provision. Now I am reading the. Well, punishment for contempt of court, they will otherwise provided in other contempt of for the car. Provided that it may be discharged or the punishment awarded to the limited possible to be the inspection of the court cannot be said like they are in routinable. One magistrate and one certain judge join.
So supposing we want that you should be satisfied also. What will be your satisfaction? And you want them to be in jail?
The manner in which they are there, filing minority.
Okay, one question. When was the interim? I think I've heard you. I think that's all. I think there's
And then-
nothing.
Yes. Period. It also giving. Here's a comment. To it by that of Rule 6(3) of the High Court.
Yes.
In case of civil. Fitting some contempt of court act. 1970. Whereas from the material laid before this court. This I want to tell. It has been made to appear that you are guilty of contempt of court punishable under section 12. Sitting in the matter will be laid before this court. Charge. You are here by direct present in court. When part of the part some under the charge and by the. Some. There should be. Has to put them there. Put it the others. The matter of joke and
Okay. Now let me hear the other side. I think that is your entire case.
is that
Unless you want to impose the punishment.
not me.
That's what. So let me now ask the other side.
This order has been directly violated.
Okay, yes. One question is, when did you get the interim order dated 8/2/23?
My lord will pick up my IA.
No, you tell me.
No, my lord, this is an application for vacating the interim.
That was not taken.
You see, that is not the issue. You first answer my question.
Last page of the.
I'm asking, I want it from him. I know it's real, you will give all that. Yes, you give, but I want to show him. So let me get his version of it.
My lord,
When did you get the order?
soon after the interim order was passed, he has handed over a copy. Got it.
When? Which date?
My lord, maybe in 30th of December. My lord, there's a reference in the
How can
30th.
it be 30th of December?
My lord, the interim order, the 8th.
Interim order is of 8th February.
My lord,
How can you get it prior to the interim order being issued?
oh, sorry, I'm sorry.
Yes, sir, when it is the
Oh,
council
I'm sorry, my lord.
jumping the gun. Let him also make some submission. Interim order was received by this respondent number 5. When?
On, my lord. Huh? Okay, continue order, sir. Please, please, My lord, it should be 15th of February, sir.
You received it on 15th February.
Because there is a communication of my inter request coming on 15th of February. That my lord, we take it.
No,
30th. Okay. All right, my lord. Let it be 13th of February. We got it. Because there is a communication from the communication dated 15th of February. I find my lord
Okay, so you received it on 13th February 23, and there was internal communication between whom?
between the regional office to the district office. Regional office to the council.
Digital communication dated 15 to the 13 to
15
13
to
to
15 to is a communication made by the regional office to the district office.
who is in charge of the district office?
District office is the divisional manager.
From regional office to district office.
Directing to comply with the interim order passed by the Honorable High Court.
Then when was it complied with?
Now, my lord, in the meantime, what happened? I filed an application for modification of that. There is a confusion. Lordship will kindly take up my IA 918 of 2020
So you filed an application
for,
modification of the
clarification of the order.
clarification. What is there to clarify?
That's what. My lord. Lordship will take up the IA first, then Lordship will take up IA.
IA.
Yes.
IA in the contempt.
IA in the read petition. consequent of the passing of the interim order, we said, give him the entire work. Entire work was given to soon thereafter. Now, my lord, the contractor, lordship will kindly have a look.
There's nothing.
My lord, kindly take up the affidavit in opposition filed by us in the contempt case.
Has the respondent number 5 filed anything? The manager? Who is the manager? Who is representing
Their
the
file, my
manager?
lord, the respondent filed,
Yes,
filed.
let me hear that. He is the main person. And there's nothing. Who are you? You are appearing for whom?
No, my lord,
You are appearing for in the contempt. Who are you appearing for?
I am for the respondent one.
One. There's nothing against the
No, nothing against me. I have already, soon thereafter, I have directed him. And
so,
I have issued a shockus to him also.
okay.
That also, then he said, well, I was, I was not very clear about the order, therefore I wanted clarification from him. That's what the respondent.
So for only respondent number 5 that were
That's what.
there appears to be
And in
something.
fact, it is not a case, my lord, that the entire work should be given to him under the,
I'm not on that. I'm not on that.
because
Whether you give entire work or not, this is not a writ court. If it was a writ court, oh, there's a writ petition is pending also.
and in the meantime, my lord, in March 2000, July 2023, the contract period has ended.
You see, one thing, you have said that it is a parallel contract work is belied by this manager's letter. You might say one thing,
No,
the
my lord.
manager is saying something. He's saying
My
that
lord,
get ready with your man and machinery to perform handling works at depot in the event of failure of so-and-so, of the first contract. So what are you saying basically? Please wait in line, be ready, in attention all the time. As soon as this fellow fails, you come in.
my lord,
That is not a parallel
let me
contract.
tell you, lordship, one fact.
Uh,
After the contract was, the work was given to him, resumed, he failed, and therefore we have to, yes, we have stated.
But that is a different issue. That is not an issue here.
Both the contractors are, my lord, simultaneous, because it is the, my lord, if one fails, we will have to maintain the PDS system.
No,
Therefore,
no, that is not the issue. The issue here is only one thing. Why was the order passed by this court not complied? That's all.
now, I have stated in my affidavit, in the contempt petition, that because of some confusion, there was a delay in implementation of the law.
When was he allowed to start the work again? When did he restart the work? No, 30 days. 30 days you are saying for which day?
Paragraph 5 I have stated, my lord, in my affidavit, in the contempt.
You see, your contention of 30 days is not correct, cannot be correct for the simple reason. You said that in the last week of December you are not allowed. Then you came to court, your interim order was passed only on 8th February. So from last week of December to 8th February is more than 30 days. And then after you, that's what, so it cannot be 30 days. Then why are you saying 30 days? When did you start the work?
Oh, yes, my lord.
So which is the date?
In the affidavit, my lord, he said from 31/3, the works, complete work will be given till the end of the contract. 31/3.
From 31/3 work has been given to him.
Given to him till the period of
31 or 31/1? 31st March. Yes, okay. Come. Let me ask. Not, it was,
Another 1 month.
you served a copy on
Okay.
13th February. So not next day. It cannot be next day. 8 and 13 is not next day.
Then, he from 13 3, filing of peace certificate.
Look, you are not sure of the date. They are sure of the date. Yes, so, Mr. Just a minute, let me hear.
Before that, we were given the image that my learned senior friend will not continue with the content case, my lord. So in this case, I am led by Mr. T. Agarwal Senior. So my lord may kindly be taken up on Monday.
And what have I been doing here, hearing? Huh?
Otherwise, my lord,
Why didn't you jump up at the first instance?
since rate petition was being heard,
I can hear both. Not an issue if you are, not a problem. I'll dispose of both.
so my lord, my affidavit may kindly be taken.
No, you tell me one thing. When did you get to know of the order passed by this court? 8/2/23 order. When did you get to know?
My lord, my paragraph 21 may be.
What does it say?
161.
You tell me. I'm not reading it. You tell me.
On the receipt of the order dated 8/2/2023.
Yes,
was
when did you
notified
receive?
on 13/2,
13/2 you received.
13/2/2020. Hello, only
13/2. Now you had now 13/2. When was he allowed to restart his work?
31/3 after getting the confirmation from of my senior manager.
Why from the senior manager the
Because
order?
I have to take orders from my senior.
Then
Because I am a depot manager, my lord. So
You are the
paragraph may kindly be.
no.
May I read the paragraph?
No, one thing. The email has been sent by you. Correct. The email has been sent by you. This is the email of dated 30 December 22. It's been sent by you. Manager Depot. Correct.
30 December, like those.
Yes. Page 29 of the contempt petition. Or of the writ petition. Of the writ
I am
petition.
not there, my lord. The copy is not with me.
Anyway,
On content case,
no. Contempt case, okay. But why did you send him a letter saying that you don't work anymore? Why have you said that? On what basis? What is the
So as
basis?
my learned senior friend has submitted, there was two contractor was going on, my lord. That earlier contractor was not cancelled, my lord. The subsequent contract with Mr. Kanaka Tree Street was appointed only at the risk and cost of the earlier contract, my lord, Krishna contract. That was also
Where is your affidavit in the contempt petition? Let me
my
see.
lord,
Let me
my
read.
affidavit is there, my lord, filed by the respondent number 3. It was
You are
filed
the
on 12/6/2020.
respondent. You are the respondent number 3 here in
I'm
the
the
contempt.
respondent number 3 in the contempt case. Ram Narayan Tiwari, manager depot.
Yes.
Hello, we have annexed the earlier two agreement, Milo, agreement with the Krishna Enterprise and the subsequent agreement with the Kanaka Tea State, Milo. That is Annexure 1 and 2, Milo. Just to bring it to your lordship notice regarding the agreement, regarding the contract clause, my lord, clause 10C.
No. I'm not on that. Why did you are the one. You see, the writ petition is going to be disposed of on the basis that you had given a letter to him saying that he should not work and he should be on standby. On what basis have you issued that letter?
Can I have the copy of the written? Can meet party in person in contact. No, but now it's a personal, in person, it has been made by. May I go through the bit? Otherwise, my lord, I have given the detail within all the.
What does it say? There's nothing. You have got the letter on 13th February. You have got the order on 13th February and you have allowed him to work
Yes, my lord.
only
Thereafter, what I have
1.5
done, my lord,
months later.
Thereafter, the conduct of the present deponent me, it is given in the paragraph number.
It's the
What I have
council,
done, my
it's
lord,
the
thereafter,
council.
after receiving the letter, after receiving the order dated 8 to 2023 on 13 to 2023, I immediately wrote to the divisional manager, my next senior, my lord,
Where,
by
please?
email dated 13 to 20,
Para.
paragraph 21, my lord. Paragraph 21. I will read only paragraph 21, 22, and 23.
Yes,
That with regard to the statement made in paragraph 11 of the content petition, I beg to say that on receipt of the order dated 8 to 2023 filed in WPC number 2, which was furnished to me on 13 to 2023, I immediately wrote to the divisional manager by email dated 13 to 2023, seeking direction in this regard. Thereafter, I wrote an email dated 15 to 2023 to the divisional manager stating that the MTF executed by both the handling contractors is not violated and the work is already in
what
compliance.
is MTF? MTF means?
The agreement, my lord.
Huh?
Model tender form, that is agreement. MTF executed by both the handling contractor is not violated and the work is already in compliance with the court order to run.
Work is already in compliance with the work order? How can you say this?
It is his version, my lord, in its email. That's what we have written.
Whose email?
This person, Tipunini.
So he's telling a, so he's telling a lie.
Asking for an instruction, what
He's telling a lie.
asking for an instruction from the divisional manager.
So he's telling a lie.
What is to be done after the. So,
Yeah.
my lord, down below, my lord, in this regard, I again wrote an email. Since he has not received any instruction, he wrote an email dated 16 to 2023 to divisional office informing that the present handling work at FSD New Guwahati is being performed by the lowest bidder, and once again requested to issue specific direction with regard to the handling work at FSD New Guwahati to avoid any future disobedience. That we have annexed, my lord, like email dated 13 to 23, 15 to 23, and 16 to 23 as annexures 7, 8, and 9. Thereafter, my lord, paragraph 22. I read it, my lord.
Yes.
That I say that by letter dated 13/3/2023, I wrote to the divisional manager stating that I have not received any specific direction and stated that the handling works have been carried out by the existing contractor and the lowest bidder, Messrs. Krishna Enterprise, and that the petitioner will be permitted to work in the event of failure of lowest bidder. I reiterated in the said email that petitioner has already been allowed and requested to perform handling work in the event of failure of lowest bidder as per the earlier terms of the contract, and therefore I requested to give suitable and specific directions to be implemented at the field level. Then, my lord, at paragraph 23, that I say that I received the email dated 13/3/23 from the divisional manager stating that the competent authority has directed to catch the handling work at FSD, and this is done by both the handling contractors, namely Krishna Enterprise L1 party as well as Tanaka Tea State, simultaneously in compliance with the order of the Honorable Guwahati High Court. Accordingly, I have started to keep the handling work simultaneous to both these contractors in.
From when? From when?
Immediately, my lord, that is on 13/3/2023, my lord. I was giving to the both the contractor as per the instruction of the divisional manager. Divisional manager is not a party here. In this regard, I would like to quote the clause.
You see,
After receiving the court order, my lord, honorable court order, then I have asked for certain instruction from my senior manager, divisional manager, who is the head of the district office, my lord, under whom I have to work, my lord. So I have clearly written to the divisional manager, kindly instruct me what is to be done, how has to be implemented. So, my lord, that was done, my lord. Then I further say that I received email dated 33. There only on 33/2023, I received the email from the FCI office, head office, my lord, Guwahati directing to allot the entire work to Tanaka Tea State only. And thereafter, I wrote an email dated 33/2023 to Messrs. Tanaka Tea State requesting to
yes,
entire
even it seems you are at fault. Not only he, you are at fault.
No, my lord, my humble submission is that, my lord, I was waiting for the instruction from the divisional manager, not from the regional office, my lord. Divisional manager.
Correct. From the divisional office seems to be at fault.
District office, Guwahati, my.
The divisional office seems to be at fault also. Division
They
manager.
are not made part.
Who is appearing for division manager? In the first term?
It's not made part.
Not made a party. Okay, so he's lucky he's not a party. But you are there.
My lord, but I have clearly stated that I wrote mail and for instruction from my senior manager. when I was given
But
it
you have
here,
not, you have
say,
not,
on 33,
you have not given the reason as to why you wrote the letter dated 30 December 2022.
If-
Who told you to write the letter?
if some time may be given, my lord, I can reply to that, because the repetition I will collect from my senior.
Who told him to write the letter? He cannot have written it on the letter. Ah.
Yes, I received notice as a standing counsel now. My senior friend is trying to mislead this honorable court, my lord. Thereafter, this case was allotted to my senior friend, my lord.
Parallel lawyers cannot interpret in one direction and it your document cannot be displayed.
I not getting writ petition means the divisional, that depot manager has not received the writ petition.
15/3/23, Sri P.K. Singh, third and standing counsel, accept notice on behalf of the court of what to find. Expect of the keep it. Now he said, I didn't have access. to
My lord,
writ
my lord,
petition.
my lord, my senior friend is in fact misleading it.
He should
I being a standing counsel, I have received the notice. Thereafter, my senior friend has been allotted that, no, I am not misleading. Because in person, I'm appearing in person on behalf of the divisional manager, district, the depot manager, my lord.
Notice for all.
I being a depot manager, I presently I don't have the copy of the writ petition to reply of that particular. Yes, I have accepted on behalf of all the respondent, my lord.
Just a minute.
Now he cannot make a summons, but he accepted notice for all.
That I accept it, my lord. Being a standing counsel, I have received and then
You
there
have
are
access to the writ, what is this, man?
my,
Another matter.
Okay,
me submit
okay,
it, my
okay,
lord.
just a minute.
Another two parallel. Okay, that they cannot, that's two parallel. And they have the.
No, no, that I'm quite sure. Parallel cannot be there. Correct, correct. No, no, it cannot be.
Race tender, you can divide.
It is at the peril and risk of that earlier tender. So that is just an excuse that they're trying to make. I'm not on that. Only thing is that the entire controversy has arisen from the letter dated
Yes.
30/12/2022.
Without.
Now, I want to know who is behind this. I want to know who's behind this letter. One thing is clear, it is the manager depot. Prima facie, it is clear he's there. It is because he's the one, the issuing authority. But was it done at his level or was it done at a level higher than him? So we cannot dispose of this pattern. Let them clarify. You please clarify. Annexure 5 of the writ petition.
I. And therefore, I should find.
So I don't want anything. I just want annexure 5 whether you're right. Heard Mr. S.C. Barbara, learned senior counsel for the petition. Also heard Mr. P.K. Roy, learned senior counsel for the FCI, along with Mr. B.K. Singh.
For respondent 3 in contempt.
No, in the writ petition. The entire controversy in the writ petition and in the contempt petition has arisen out of the letter dated 30/12/2022 issued by the manager bracket depot, FCI, Guwahati. Wherein the petitioner's contract work has been stopped to enable the earlier handling contractor, respondent number 6, to restart the contract work. The FCI counsel shall file affidavit, additional affidavit. Or have you filed any affidavit? Okay.
I have not filed.
Shall file affidavit. The FCI counsel shall file affidavit on behalf of the FCI within a period of 10 days. specifically stating as to whether the letter dated 30/12/2022 bracket NHK 5 of the writ petition has been filed unilaterally by the manager depot, or the same had been issued on the basis of some order issued by the higher authority. If the said letter had been issued on the basis of an order issued by a higher authority, the letter of the higher authority should be annexed to the additional affidavit. The FCI, the council shall also produce the report on the next day. List the matter on.
Obligement.
Then get to the bottom of it. Because you see, it might not, the manager depot, I don't think he will be doing it by himself. I'm quite sure there is something else behind it.
Not so that far.
It is not so, then we have to take him to task.
We have, he's police person,
Acha, you have,
out of record, my lord.
okay.
Sokos has.
Okay, you place everything.
Sokos.
Oh,
Sokos
okay,
has
just,
been
just
issued.
write one thing. There before say, Mr. P.K. Roy,
No, but not, let it not, that is the written instruction.
why not?
Why not?
Why not?
Why not?
Not a written structure.
There is
No, no.
written instruction,
No.
telephone and we have.
Acha, okay, Mr. P.K. Roy, learned senior counsel for the FCI, can also obtain instructions and clarify in his affidavit as to whether any action has been taken on the manager depot in view of the letter dated 30/12/2022 issued by the manager depot. That's all.
By that, your lordship is indicating some definite finding. So the fault is with the. The lordship will have to hear the whole matter.
No, that is why you can easily say, yes or no.
And I'll find my affidavit.
Look, it's very simple. It's very simple. If he's,
That
if,
case, Lord,
uh,
that case.
uh.
The manager may also file his, but your lordship may. Not
Uh,
liberty to file to him.
the respondent number 5 is also, the respondent number 5 also. The respondent number 5 in the writ petition may also file affidavit in opposition within 10 days. Tell him. It's only whether the contempt contempt case, the higher of the court will fall either on you or you and a higher authority. That's all. Huh? I don't want to give others. It is a
Apply. My lord, please, my lord will see the last judicial order passed by this court. Because I am the beneficiary, my lord, since March, my lord, on one or the other pretext, my lord, they are taking adjournment. On the last occasion, they agreed before this court that today they will. My
on the prayer on behalf of Mr. M. Biswas, learned counsel for the respondent number 5, to the effect the absence of censure. This matter on change. This is of 6/5/2024.
My lord will, yes, and 28/5/2024, my lord will.
Where is he? Which court?
It was there.
Yes, yeah.
Well, since morning, because that is the precisely I apprehended that probably since they are enjoying and stay order, my lord, they will not fall for this, what you say, this affidavit in reply which they filed yesterday. I took the initiative. I moved an application before the requisition was moved by me. Because last occasion also on one or the other pretext, my lord, they took adjournment.
Okay, we'll list it there tomorrow. Definitely tomorrow medical ground, what to do?
Yes, yes. Sometimes
Unless you say that no, he's 100% fit. Nothing will happen to him. I leave it to you. If you are
No, my lord,
objecting that way, so I will allow.
That I will not say, my lord. As a council, I will not say that, my lord, but at the same time, my lord, we are also. Day after tomorrow to keep our.
Thursday.
Thursday.
The only issue is
Oh, you're
that
not-
I'll be in Itanagar.
Okay. Too many cases.
That is the only issue, because that is why I fixed it today. I was under impression that.
You see, Mr. Council, either you object and I hear them saying that he is not present because he's sick, and then I hear you and decide the matter. If you want
My
that,
lord,
I'll do.
my lord will fix it on Thursday, my lord, if required, I'll do it online.
I don't think you'll do. Not when you're in Arunachal. Yeah, Arunachal, you'll be in the court and you'll be online. What? While walking around in the corridor. While walking around in the UK court.
Then, my lord, please, my lord.
All right.
My
On
lord,
the
for my lord, last chance that may be recorded, my lord, because last time also there was a judicial order, my lord, that they will not take any adjournment of this.
correct. No, the last time it was adjourned due to paucity of time. I'll just read the last order. It says by a different court. It says due to paucity of time, the matter could not be taken up.
My lord, I am relying on the order of 28/5.
28 time?
Yes.
It is. But then what to do? He's sick. Unless you're a doctor and you say, no, he's perfectly fine, he's telling a lie. I don't know. It depends upon you. On the prayer for adjournment made by, on behalf of Miss Deborah, M.D. Sharma, M.K. Sharma, Direct Counsel for the petitioner. This is the matter on Tuesday.
That is.
Interim order to be continued till the next date. No further adjournment shall be given on the next day. No further adjournment. You tell your senior, if you ask for adjournment, I will allow the adjournment, but I will vacate the interim order.
My lord, here I am praying for 2 weeks time to file my affidavit.
Mr.
RS Ronghang. RS Ronghang. I have no instruction about this letter, Lord. This may be due to the virtue of the last order, Lord.
Why don't you ask? Yeah, for whom?
I am for the respondent, Lord.
When you ask regarding this, we will take it up after, we'll take it up at 2 o'clock. You ask whether the petitioner has to appear. On 10/6. Oh, how much time you take? 10 minutes, 5 minutes, how much?
15 minutes.
15 minutes. After that you come. You give a copy to him. Have you got another copy? You show him. No, not that, I put. Okay. Then okay, item, hearing matter. Huh? It's, this is, WPC 26/2014. I think page 12. Yes. The 2014 order. Ah, there was some, there was a education, what? Course. There was a course for the referees. Yes, yes. I reach in time. Yes. Which page are you reading? Yes, 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 yes. Then, yes, yes. Yes. So this has been sent. This is correct. Twenty-five. Huh, please? Yes. One year. Who is Ankur Datta? Or the SR? So your letter number 3rd June. What is this 3rd June? So your application was with documents or without documents? Your application was with documents. Application has been sent. So belatedly. No, page 25. It has been sent, of course, not in due time, but 27 days. There. Page 19. Page 19 is not a letter. Page 19 is not a letter. Page 19 is this. It is a letter. The contempt petition. This is a contempt petition. Okay. Page 19. Ah, okay. Yes. Have you got it?
No, in fact, on the last document, I had applied the code that there is no such record. Emails of 2014. In fact, I'll just place certain things. Firstly, he was the then honorary secretary of the institute.
No, how can we go to the merit? See whether you have complied with the order or not.
Yes, yes, yes. I will take it to that. Now, what you will see, the last date of application was 30/3/2014. The requirement, the course was supposed to start from the 5th of June. The last date of receipt of application was 30th of March 2014. Now he approached this court on 23/5/2014. But the fact and beyond the time, firstly. Now, what you will see, there was an order.
See, that those issues.
No, I understand. I'll just place Milord the fact. Now, what you will see, what had happened, Milord, initially this Lordship kindly comes to.
So it's very simple. Did you send it or not?
Yes, Milord, yes.
Where's the proof?
Proof is this, Milord, because I have annexed this document. And in fact, Milord, what my learned friend has just referred, and what will kindly come to page 17 of the contempt.
Yes.
Now, Lordship, the note below.
Yes.
5/6/2014 reported on 5th of June at 6 a.m. at Cuttack and returned back as we have received no document from Assam Football Association in support of his eligibility. Now, we say that he is not eligible. It's not that document that no document was received is something different. Here is no document in support of his eligibility. So it can be the other way. It's a question of disputed fact, Milord. Now, how can he say, Milord, that this document was not received? The Honorable Court's order, if your Lordship kindly see, at page 15 of the contempt.
Yes.
Look, what had happened, Milord? After the initial order, Milord, we approached this court, Milord, by filing an application under 226(3).
I got all that.
Now, Lordship, thereafter, Milord,
Yeah. Parroting whatever has been said earlier.
yes,
There's no point wasting time.
yes, Milord, they should accordingly forward the application with their comments. The respondent number 4 and 5 must, however, make sure that the report and commission reaches the All India Football Federation in due time. So, Milord, thereafter, we send it to email ID, Milord, that is your Lordship has already learned has referred to. And Milord, it was also sent through registered post. Sorry, through courier. The page 19 is the letter. This order was passed on 2/6, Milord. We sent it through mail, firstly. And Milord, thereafter,
Page 25.
page 25,
What is this by courier?
by courier.
Dated?
4/6 on the left hand side. You will see
4614.
4/6/14.
Now, as this courier person, when did they give it to them? Anything? Is this a disputed question or is this page 25? Is it a case that this application was not sent in terms by way of this courier? Is it a case that the application was not sent by this courier? Mr. Counsel, at the end of the day, they have already sent. So, how do you know it has not reached? Where? Additional affidavit. Yes. Okay. That consignment of what? Of this? Uh, okay. Where?
Will tell me, Lord, since his lordship is already
Huh?
looking to, since lordship is already looking to page 6, lordship will see this is an express service on the right side, status delivered, then just done below. Service type, express. What can more be expected? I sent it to register firstly through email,
Order of this court was passed in 2013.
14. Two 6 2014. Email was sent on 3rd. By courier, it was sent on 4th.
Orders of 2614.
2/6.
Okay. Orders of 26, and you sent it on 4/6.
No, my lord. 3rd, it was sent to mail, which was duly acknowledged, my lord. That is, there is an acknowledgement.
And the other, and then thereafter,
And
2 days later, I mean.
No, my lord. On 4th, the courier was sent.
Correct. 4th and 2 means 2 days later.
Yes,
2 days later.
2 days.
What is that? They sent it, they didn't reach in time. That's our How can you say that as yeah, this document at page 70 says that no document received from in support of his eligibility does not. But your application was sent. How do you know? How do you know? Yeah. Mr. Counsel, first of all, this letter, page 27, is of 1st July. Correct? Okay.
Contents. It said the my lord, email was received on Wednesday, 4 June. At 5.
They have received only the letter of the association, federation letter. Yes. What?
Here, my lord, also will kindly appreciate it. The letter, no doubt, my lord. This is the letter written by the which your lordship will, that is in this. Lordship, this letter is, my lord, page 19 of the contract.
Yeah.
This is the letter which was sent to me.
Correct.
Now, lordship, whether any documents were sent or not, is not explicit from this document. This is his statement. And my lord, there is a document to show that the letter which indicates, my lord, that there is no letter in support of his eligibility.
This is a 2014 matter. Why is it?
And in fact, my lord, the condemned Miller, he is in his deathbed. My lord, there is no communication, my lord. On the last occasion, I had appraised this court also.
I don't know, because he was in his deathbed last time.
No, no, the deathbed or not, that is not the issue. Whether it's deathbed, just because he's dying, what?
No, no,
He
even that,
doesn't have any right.
no, no, that is not Milord, because even in the writ petition, ultimately Milord, there is nothing in the writ petition as of now. 2014 meter, the map, there was a force. He was not eligible.
There's
That
no
was,
more, the force is not there.
no, Milord, that was.
So the basically the writ petition has become instructed. And what is this other writ petition? MC, only something. 2014 matter, now nothing is clear also. How can you prove that when it's not mentioned? No, first order, but the second order could have been complied with. They sent it on 4th, everything. But then this court did not say that you send it by 2nd or 3rd. Just said sent it. Inside. Yes, Mr. Day. You have not sent it on time.
How can it be, Milord? Because on
If
third,
the course is going to start on 5th, then why did you send on 4th?
because third, we had already sent a mail, Milord. That is on record.
What mail?
That was, that's what is referred, Milord.
Mail is I mean, your reasons
No, Milord.
stating why he's not eligible. That,
No, not only that, Milord.
that is it.
Milord, because there was a rider in the
Which mail have you sent? Show me once again. Huh?
mail is not been annexed, but Milord, Lordship, page 27 of the affidavit in opposition, Milord.
What mail is there? What mail have you sent?
I'll just take it. Milord, your Lordship will kindly come to page 24. 24 is the letter, Milord. AFA cap.
Who is this honorary secretary? Who is the person?
Ankur Dotwal at that point of time. I am appearing on behalf of the Assam Football Association as well as the content Milord for the secretary, honorary secretary, at that point of time. Now someone is different. Someone else is. Lordship, this is
So, it can be done only against that person, Ankur Data.
exactly. That is what I said, on the last occasion.
Where is Ankur Data?
There is no trace. Because
No trace.
no trace, In fact, if you can produce, I have nothing to say. In fact, there is no contract. Even I have sent letters. In fact, I have sent mails to the office also. I do not know his personal address because if the lordship sees the address is in the Assam Football Association address. In fact, there are certain things that happen. He was even in jail for some, for some anomalism.
Even if we are going to punish him, or even impose a fine, how do we get his present?
We'll have to track it.
Okay, right.
Reactive means your lordship.
Right, Mr. AK Gupta, learned counsel for the petition, and Mr. R. Day, learned counsel for the respondent. This contempt petition has been filed for non-compliance with the order dated 28/5/2014 and 2/6/2014 passed in WPC 2653/2014. Next slide. The gist of the case is that the petitioner, who is a former national level football referee, aspired to be selected for the referee educators course as per the circular dated 12/3/2014 issued by the All India Football Federation. The petitioner applied for participating in the referee educators course via application dated 25/3/2014. The said application was to be routed through the Assam Football Association, who was routed through the Assam Football Association to the All India Football Federation. As the petitioner's application was not being sent by the Assam Football Association to the All India Football Federation, AIFF, huh? Then All Assam Football Association, you write AFAF. The petitioner filed WPC number 2653/2014. Next part. This court passed an interim order dated 28/5/2014 directing the AFA to immediately forward the petitioner's application to the AIFF for necessary action, as the referee educator course was scheduled to commence on 5/6/2014. Next part. The petitioner's application was not being forwarded by the AFA to the AIFF on the ground that there was defect in the petitioner's application. Full stop. Thereafter, this court passed another order dated 2/6/2014. Why is it pending for so long? 2014. 10 years have gone by. A dead horse, in a way. 2014. Stating that even if the petitioner's application is assumed to be defective, an interim order having been passed by this court, the AFA was to ensure that the petitioner's application and their report should reach the AIFF in due time. Next part. The petitioner's counsel submit that the impugned orders submits that the orders dated 28/5/2014 and 2/6/2014 has not been complied by the respondent, in as much as the petitioner's application has not been forwarded to the AIFF. Only the only the letter dated T6/2014 issued by the respondent which is to the effect that the petitioner did not have the requisite criteria for participating in the referee educators course was forwarded to the AIFF for consideration. In support of its contention, in support of its contention that the respondent did not comply with the orders of the court, the petitioner counsel has relied upon the letter dated 5/6/2014 issued by whom? Page 17. Huh?
It was a letter.
Issued by whom?
It is a letter of the petitioner.
Okay.
Letter of the petitioner where the acknowledgement has been given.
Okay, what have I said? Submission. The petitioner has relied upon his letter dated 5/6/2014, where there is an observation made by the authorities who are to run the referee educators course, stating that the petitioner had reported at Qatar on 5th June 2014 at 6 a.m. and had returned back, as they had not, as the, what is this HOR? What is this HORAIFF? As the head of referee, AIFF had stated that he had not received any document from the AFA in support of the eligibility of the petitioner to participate in the referee educator course. The learned counsel for the petitioner has also relied upon the TTDC courier receipt bearing number K719-21579, the tracking results. What is this? The tracking report of the said DTC receipt and the letter dated and the letter dated 1/7/2014 issued by the AIFF to show that the petitioner's application had never reached the AIFF. Next one. No, next one. The according the petitioner's counsel that as there has been a blatant violation of the the interim orders of this court. The respondent should be penalized under the Contempt of Court Act. Next, Mr. R. Day, the learned counsel for the state respondent, for the respondent, comma, on the other hand, submit that the documents relied upon by the petitioner's counsel does not prove that the respondent did not send the petitioner's application to the AIFF for consideration for participating in the referee educators course. He further submits that the petitioner's application had been sent by way of CTCC courier on 4/6/2014, and as such there was no violation
As well as by email.
as well as by email
On third.
on 3/6/2014. As such, there was no violation of the directions passed by the. That's all.
The only thing, the letter which we have referred, the note. My foundation is that, this does not,
So we further submit that the note put in the petitioner's letter
page 17,
by the
HOR,
HOR AIFF does not state, does not show that the petitioner's application had not been sent by the AFA to the AIF.
actually, it is, my full foundation is that, the line is, we have received no documents for so and so in support of this eligibility. My full foundation is that otherwise not eligible.
In as much as the note states that the AIF had not received any document in support of his eligibility. They accordingly submit that the contempt petition should be closed. Okay, I have heard the counsel for the party. Then make it peer review, okay? Peer. Then, peer review for this. Or then in the other cases, in fact, right? Mr. Spencer, learned counsel for the petitioner, and Mr. Ade, learned counsel for the respondent, submit that as the matter has become infectious from other, this petition can be closed as it, the writ petition, and the miscellaneous factors and what about 548? Contempt, where is the question? This is a contempt case. Where is it? Well, this is not a writ petition. How can that be? It's instructed. How can you say you convict him for contempt, but you please ask him to pay me compensation? How can it be? It's not like America or something like that. You go to the civil court for that. Right. Uh, submit that in view of the petitioner having crossed the age of eligibility for participating in the referee educators course, the writ petitions have become infructuous. The writ petitions and miscellaneous cases have become infructuous. Accordingly, the writ petitions and the miscellaneous cases are closed as infructuous. I will think about that. Yes, madam, come. Yes,
I have obtained the instruction of it. Let the petitioner appear on 10/6.
10-6.
Yes, sir. At
Okay.
11 a.m.
Okay, right.
Along with all the documents.
Miss,
And documents.
miss, what is your
Content
name?
may be closed, sir.
Huh?
This content property may be closed.
Wait, miss, name, you write it down and give it. Appearing for the petitioner submits that the petitioner has received a letter dated 9/5/2024 issued by the Joint Secretary, Government of Assam,
Department of Revenue,
Department of Revenue,
Karbi Anglong Autonomous.
KAAC, asking the petitioner to appear before the said officer on 10/6/2024 at 11 a.m. along with relevant documents. Full stop. However, the petitioner had also received a phone call yesterday informing him that that he need not appear before the concerned officer. Correct. That is what was the phone call? Ah, so the second information was received by you through WhatsApp again. Through the reference. However, the informing him that there was a mistake in the letter dated 9/5/2024. This is not a notice. Mr.
R.S. Rongham.
R.S. Rongham.
Rongham.
As spelled
RONDHAMD. Rongham.
Rongham. Appearing for the respondent. Submits that. No, was instructed to obtain instructions with regard to the letter dated 9/5/2024. Above letter dated 9/5. He has informed the court that the petitioner should appear before the Joint Secretary, Department of Revenue, KAC, on 10/6/2024 at 11 a.m. List the matter when? After that date. When? Since you are going to appear on 10th, then I don't think any contempt will be there after this. 20, what? This is a matter on 14. Okay, this is a matter on 20.
Apply.
Look, this matter, the last I heard it was in February. Yes, they ordered something, I think so. So there was a blacklisting. We are challenging the blacklisting. What was the main ground of challenge in the blacklisting? Let me read this out. So I think the entire issue has arisen out of the petitioner having allegedly taken a decision that it would not make any supply of pipes beyond the value of rupees 12 crore. So now from where did this 12 crore come into the picture? From where did this 12 crore come into the picture? Order of this, But have you written some letter saying that you cannot supply pipes beyond 12 crore? Give me paper. Yes, paper, one second. Okay. Yeah. Put up the list. Where- where the- huh? Okay, go to the- Yes. But this is to Bharat Petroleum Corporation Limited. You are Mukund. You are Mukund only product. Huh? Okay, you have written this letter. Yes. Go to the third column. Yes. Huh? Okay. One, two, three. No, no, 369. Total amount LOA quantity. Ah, 4 items. Correct? Yes. Yes. So, yes. Balance to dispatch against first call. Balance to dispatch. So the, so that has been dispatched. Item one has been dispatched. No, no, it is balance to dispatch. It is balance. Balance to dispatch means the balance that is to be dispatched. So no, so does it, is it correct? That so there was no, there was no dispatch order for the serial number one.
The dispatch order was there, my lord. So far, item number F is concerned, that the serial that F,
F, so that is a dispatch
that is dispatch.
against first
That
call
they
of
have
inspection.
dispatched. But thereafter, my lord, because of want of local content, that the subsequent order can be dispatched, because we have said that initially they have, while bidding, they have shown their local content 82.36%.
No, and look, please come again. So it is, what
bid-
percentage?
In the
Percentage
bid,
of what?
in the bid, they have submitted that local content is 82.36%.
Local content of what? Locally purchased.
That I will show. But one thing, my lord, before.
So what does it mean?
Yes.
So this item is this iron or what? What is this?
No, this plastic pipes, my lord.
Plastic pipe.
Normally, my.
So this is 32 plastic pipe, the
Right.
first one. So total LOA quantity, letter of acceptance, quantity, metric, what is this, MTR?
Metric ton. This is will be meter.
Huh?
But we have converted into kilometer, it will be 320 kilometer. But
It is MTR, it says MTR, where is the question of kilometer? They don't understand the,
oh, yeah, that's
that is
correct.
the
Before that,
basic.
my lord, I just want. No.
No, I need everything because I heard it in February. Now, though, I don't remember at all what I heard that time.
We have taken the jurisdiction point, in this matter,
We have taken, that is one of the points.
one of the points, lots of people also decide that.
Ah. They are probably going to take arbitration also probably.
I don't know, but I'm newly engaged yesterday only, my lord. I'm engaged newly, my lord, yesterday only, my lord. Night.
That, yes. Because of that, no? Ah. Yes. Only thing is that now I've got to relate back to those notes, where I don't remember what I heard in February. Yeah.
That is not possible, my lord.
Yes. Yes, yes. Uh, uh. We will. We will. Let me get the issue straight. At least one, otherwise. That's all right. I want to understand this because the entire controversy has arisen due to some, yes. Where's the tender notice? Let's go back to the, unless I go back to the basics, I don't know what.
52,
Page
52.
52. Yes. 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 Now, first of all, what is this PPLC policy?
Purchase different local content.
Page 22. Okay, then, so, yes. 169. Where is class 1, class 2? Where- What will be the example of this local content? Raw materials of a particular state or of the India or something? Or that in the context of India. Then, okay. This page 171. Okay, and that is your interpretation. Interpretation of components. manufactured in India. So if yours is the raw product and there's the finished product. So, so according to you, raw material purchased in India will come under what? Will come under the local content. And raw material manufactured in India. Of the pipe. Of the raw material. Of the raw material. Correct. The question is the going on with the ultimate purpose of okay, so instead of 80, it was 50. He submitted like, and like that person has not been taken, not been that's not the region. The proposal was other things, but that's a different stuff. That 80%, that is wrong. So they are only when it should not, let's say, okay. Balance quantity. Balance quantity. Okay. Now, he said by the agreement that where there is a spot. There are 15 crore worth of data. Letter of allotment was out of which they expected now the letter of electricity board is that I have said that I could not take it by 3 crores of goods out of 12 crores. The consequence. There's 289, 72. Yes. Last person that I have. 272. Fine. This is yes. Last person. Yes. Or I need these the fact that I got board. Hence, astute that. Also, right. You have hope. Contact with the students. Also, confirmation implied that they shall be not be able to supply material but solution and that the contact with the works of both the participating. Now they are saying one is particular. Huh? One is the letter of acceptance that you are getting for the first part. Now this flow, third flow, the
first call from
Where is that? Which page is that?
your friend in the petition, you will also write in the petition I mentioned.
Where is that page? Three 69.
The petition I,
No, no, in this 369.
petition quantity is there.
Yes, now how do you relate what you have said this now with this quantity?
The petition is there. Yes, sir. Of the first place to report the development. Of 15 days.
Correct.
And the first call was for 12 days.
Where do you see 12 crores? I don't see 12 crores.
12 crores in the
In,
development.
in page 369, 12 crores is not there.
Amount is mentioned below in the order. The petition order.
No, no, in this, what is this page 369 about?
This 69, the quantity below.
Quantity is, one is 32 mm, 5.2, 5.
Below quantity. In the first T is the rate of reference function.
Ah,
It becomes clear about 15 days.
this is 5,25,000. 5,25,000.
Of 15 days. So, all right.
So all these 4 items will come to 15 crores.
Now, the second is the first call.
Second, what do you mean second? The total LOA,
D.
D, first call, yes.
This quantity comes to your control.
So all the 4 items.
All of it. Now, they are saying that we have said that it is not able to supply in crores of the.
How do they say that?
No, no,
Why do they say that?
just let me know.
Okay, because of this letter.
Because of the data that is said here, that is by first program. Of the slide below, local slide. You mentioned that we will be able to supply the first project.
Okay, so the first call item is 12 crores.
First.
So you have said that you can supply up to the first column.
Now, they have said in the order that we have said that we will not supply
Beyond,
out of control.
that will become 9 crores.
They come to 9 crores.
Ah.
But we have always, we are saying that we find it in the parents order.
Ah.
The data gets for not minute. 69.
Yeah.
The last different letter.
Yeah.
Further, we are yet to get section for the balance and the 4P1 is refer to column number F of record info. So the kind of here, appearance of the quantity mentioned in column G. Column G, you'll also see. And at above, table at the earliest. We said that whatever has been expected, kindly, and the quantity for which the LOA, the first call was given, and inspection about that, and check it. So, the percentage which they have calculated, the report, the logic calculation 50 crores, 15 crores, from 15 from this percentage comes only the 12 crores.
It does not come with a 15 crores.
No. It's kind of. So what I was submitting that the basis on which the so-called publication. I have said, I have not been right, it was out of out.
mentioned here. And if they say that 12 crore is the only amount, the amount. I've never said, I've always said that I'm going to supply. For the good. So the basis of the blacklisting order itself does not exist.
So everything revolves around page 369. Now, just once again, let us go through 165, 369. So there are 4 items, 5 different 5 millimeters of pipe, whatever. So the total LOA means letter of allotment. Quantity MPR means meter. So, so these total meter length of all these 4 items, how do you say it comes to 15 crore?
The amount, because they don't explain the.
Yes, in para?
The 29.
Para 29 at page 41. Page 40.
Forward.
Okay. Yes. Oh, page 40. 40.
Right, right there. If I must have got of this is going to was only what is going to happen by going published. If I must have published, even if there is by the parent. On the other hand, only construction of the call growth. On the other hand, as well the part of for not indicated the base of average at the benefit to be up by the study of the support not half at the top. But the top most articulate
What is this holiday list?
so politically whereby how the
Okay.
amount for the putting them for
But the total value was 50 crore. Now, I will never say that the data is accurate. I requested them that kindly get the order for very much me of much more. Now, you are practicing me or being not being able to supply the of the floor. You are saying that I check that out of the source I get it. Crore. Which comes to this percentage. But after the percentage, it will never come 24.70%. The work order. You see, the only.
But how do I do that?
It will calculate now. Give the percentage. Question is that we got that it also a if the existing photograph are getting that I expected in out of the it comes to the which is kind of 16 instant on the west of the north of the state. Then the existing photograph getting asked now if the party out of that effect. Then subsequently you cannot say that no, this was correct, this was not correct. You have to go at the you have to go by the order. If you have applied a bank, with your mind developed, that you right, meaning thereby calculate which is incorrect. I request say there are time dated, I give me the correct order for the first part. And they have
Where is the notice they have served you?
proper note.
Yes.
Your first date,
Yes. Yes.
Also, what of my first step. And first of all, one affect of I of people. But so how much of the supply that is people are how right? What right? That not just like the people from communication better. Yeah, then that's also by very first if there's based on the definition of what should be the case before the definition of the kind of not different states that when the work for the one should be for the process of the action are the definition of the down that the different power is that of the side the direct part as the first power is the and only after that of the should by the when the economic opportunity is of the first step of so only the part of asking for the that has been by when it's zero the of in the time that with access one. The economic opportunity that the base of the cost has never denied the supply but both not the other. The economic denied stability of the gate. The first gate is that finish the gate.
I will take it up after lunch. How much time will you take?
I'm just
No, not required. It's not required inside of. Yes. 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 How did they come to that conclusion? No, but why did they say that you will not be able to supply that 24%, whether it's 24% or 20% or what? No, what did you say that you will not, that you have not given the dispatch order, or why? Why did you say that you will not be able to supply this 3 crores worth? Ah, ha. Ah. No, but according to you, have you said that you will not be able to supply 3 crores out of 15 crores? So up to 12 crores you will supply. Ah. No, that is why that's why I'm asking you, on what basis have they said that you will not supply that 3 crores worth of supply? Ah, ah, ah. Beyond 12 crores not be possible. Where have you said that? Hey, yes. Okay, so according to you, you can supply up to 12 crores as per the first call up, as per 83%. In that 83%. No, no, that local content of 82.3, how much can you supply? No, that has come down. Uh, correct.
They have accepted it. Proposed notice that
That we could cater only the first call up PO quantity under 50, huh? So you cannot, yeah, so yeah, so where have you said that, so what about the other, if there is some other call up?
You, if you say that we give color, before giving a color mirror, before directing you to supply, can it reach your contact right? If you will not issue a direction to supply balance three vote, and I said that I will not supply, which of them get me a right? out of 12 crore, you have taken state only of 5 or 6 crore. Even the 12 crore quantity is pending. And you are requesting me on a hypothetical question, which is also wrong. Because they have in their mind that I will not supply 3 crores out of 12 crore. That is in their mind. I feel wrongly they have understood it. That I will not supply 3 crores out of 12 crore. That is they have understood it.
Well, it appears so.
I
It
think they
appears
have
so.
understood it. That is not
No, not, is it 3 crores out of 15 crores, I think?
so is it not you mentioned it clearly. But must once we get the which people know about 12 crore. Going for 5. That's the best. Right? What's percent? These people of 20%. 12 crore.
So let us see. What was the total amount? 15, how much? 15 crores? How many lakhs?
That's 2 lakhs with tax.
Fif- 15 crores, 2 lakhs? Yes, 140. And so 3.07, 10 to 62.07 will is how much percent of this 15 crores? How much?
20.50.
Is no, no. Supposing we take it against that 15 crores, 20.4. And if it comes to that 12 crores, then it comes to 54. Again, this 12 lakhs, 12 crores, 72 lakhs.
You have assumed that that was the source of the control. I feel wrongly. The backtesting order is based on his findings. Once the backtesting order is based on his findings, and there was a possibility to any order has to be coming on the basis of the content of that order. Backtesting is not a small order. If you pass some order of backtesting, assuming certain facts,
Supposing they say it's a mistake. It's not a mistake. It's not a mistake.
we say, it's about what mistake. Correct. Because we are not surprised, yes, giving the letter that they like.
If they say it's correct, then I don't know, you have to do some explaining then.
Because gives the letter at that is tonight.
Yes, 369.
But we had the fixing cost for balance quantity of 4 of P1.
Wait, page 69. 9. Yes. Further. Yes.
We had that fixing cost of 0.1. Please, the first column number that of the first level set. So it's 9 plus 9. There is a in G and F.
No, again, this page 69.
Right.
This entire amount totals how much? The cost of this entire amount. How do you get that? How do you get the 15 crores? Where is that? Huh?
Okay.
Yes, yes. Okay, okay. Huh? Yes. 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 Including of all taxes. In page 272. 270. Huh.
Page 270. That the column number 3, estimated value of the contract,
Okay.
the 15 crores, including GST or 18%. So it is paid.
217. Which portion?
17,
Huh?
217, serial number 3. The contract value of the tender shall
So,
be
so how much is 18% of 15 crores? Huh?
inclusive of
That is
GST,
what.
18.
Supposing we minus 18%.
That is then minus
how much is-
12 lakhs, 12 crore 72. That minus that will be amount of GST.
Yes.
Now we're working mechanism, no? The total contract value of 15 crores.
Yes.
Now in the include the order, 17, you're also see.
See?
62. Okay, but in order. 69. Huh? Yes, yes, mirror line. rupees 72 million.
Yes.
You'll also see the use per what? The contractual obligation of supplying 12 crores something. The contract value is of 15 crores.
Where are you reading?
Well, 372,
Yes, which para?
the last but one paragraph,
View above.
view above. It is noted that against the fulfilling the contractual obligation of supplying rupees so and so work of so and so pipes against the contract of so and so. So and so they supposed to supply materials worth rupees so and so against them. Now Velocity by there the problem by Leonard and Reddy. The contract value will be of 15 crores.
Inclusive of GST.
Now I will explain before Velocity judgment that the contract value of sale price is always inclusive of GST or taxes. So it is always inclusive of. So it has to be considered 15 crores. Now, the main question which arises with consideration for Lord Similar, that have you placed the order as per the letter of allotment? First call means what, my lord? Whether you have placed the order in respect of the entire quantity as per the letter of allotment. If you have not placed the order, so by my little knowledge, whenever you contact, when we say that you have failed to perform, it's only when we direct him to perform and he requires it. If you have not directed me to supply, you are not issuing the letter of the letter of call letter. Can you say that there was a breach of contract?
But then page 369, you said that this amount is for the entire contract. You know, it's page 369.
369, you know. I am saying first call. I'm saying first call because first call was the only call issued.
First call is for how much amount?
This is the amount, 12 crore something.
So 12 crore,
According to that, 12 crores increase because it's only value of the good
without the tax,
without the GST.
without the
Now, if it is without the GST, not so far my knowledge goes, I will calculate it. If it 8 to 12 crores, 18%, how much it comes?
I don't know. You tell me.
I just it would make 1 second. 12 crores, 12 crores, 72,000,
This page 369,
15,500.
is it without GST or with GST or what is this?
But I will the NH, sorry, the
NHS
column,
21.
column F, my lord. The lordship may see column first inspection call raised on 1/2/2023. That amount is the variation is there. Then dispatch against first column. That means he had supplied this material worth 4.52 crore. So as of now,
4.52 crore?
yeah, total supply he has made.
So how do you know where is it
That is
written?
my lord, that is my lord. If this is in meters, if you convert it, it will be kilometer, 320 kilometers. Fine. So that worth rupees 4.52 crore.
How do you know that? How can I, how do I?
Yes.
Hello, you asked me ask the question, how review of the dispatch order was issued by? There has to be an inspection.
Yes.
And
This is
how much,
this is after inspection.
how much inspected and how much place order they placed. I annexed the paper. How much what are the goods they have placed the order for display.
I'll have to juxtapose the page 369 with I think 216.
No, no. Right? It's 216. Okay.
Five. You see, how do you correlate page 216 with 369? Because you have said that 369 amounts to the whole supply order. And this is approximately 15 for page 369. And then I ask you, how do I know that this page 369 pertains to the 15 crore order? And for that, you have taken me to page 216. Now, how do you correlate 216 to 369?
But I the repetition again, my lord. Lord, page 369, simply to review everything. 369, once again, if you want something.
Yes, yes.
I was something before Lord, that the total quantity ordered was in C, that is LOA.
See.
C.
Yes.
Now thereafter, my lord, the first call was D.
First call, what do you mean by first call?
So they give that this is the order we are placing.
Okay. Out of this,
Out of this.
out of this C, we are placing D.
This.
Ah.
Now out of that, E you also see,
Therefore, they have inspected this much.
only this much was expected.
Ah.
That is much less the quantity you will find, also find of the first call.
Ah.
First call was also see first 5 crores 5 lakhs 25,000, here 389.
Okay.
So the full quantity was not inspected.
Correct.
Now after inspection, without an order comes that you dispatch this to this place, this place.
So was it dispatched?
Now dispatch you'll also find at F.
Yeah, they have dispatched.
That is also less than the inspection.
No, that is same as
No.
inspection.
No, also see,
No, for 32 it is same.
but other quantities are less.
Other quantity for number 2 and 4 it is less.
Less. So full quantity they have, whatever was expected, that also they have not ordered us to dispatch. So two issues arising. One is the first call which was made. You have not given a dispatch order for not either inspected the full quantity, nor dispatch order. Secondly, the difference between the letter of allotment and the first call, whatever quantity are there, you have not issued any second call. You have not issued. You have not directed me to supply. You have not directed me to supply. Now my failure will arise, my lord.
Yes.
My failure will arise only when a demand is there. When a pilot you're also aware, defaulter will be when a person is deemed to be defaulter only when
Okay, let us see this letter dated 21/3/23.
21, 323, no?
Yes. That is mentioned in your
Reply, my lord.
yes.
Page 313.
Huh? Yes.
we said that we will be able to supply first to call out. First call. But the issue which arises constitution for also is that, my lord, if the second call is not there, assuming, my lord, the first call is supply over. First, the first supply has to be over, my lord. First, whatever call is there, that supply is to be over. Thereafter, they issue the order, second call, and ask me to supply. I say that no, I will supply. But if of the first call also, you have not taken the full quantity, can you say that the quantity we have not ordered also, there is a breach of contract? Breach of contract can only arise when somebody is directed to perform and he fails to perform.
And what happened if prior to them telling you to perform, you yourself say that I cannot perform, then what
That is
happens?
not a breach of contract.
Another bit of it.
That is not a breach of contract. Because of the reason that first call quantity you have not taken. First call quantity, if the first call quantity you have would have taken the entire quantity. And I say that I will not supply the balance one. You yourself have not taken the full quantity of the first call also. Can you blacklist me? Blacklisting will not add something to my little knowledge.
No, you have got a lot of knowledge. We are the one with a little knowledge.
I know. The breach of contract, my lord, when somebody is asked to perform and he is not performing. When the asking for the to perform situation had not arisen, on the hypothetical, it may be that, my lord, after the first call of supply is over, and the balance quantity is ordered, I may supply the balance quantity also by suffering the loss also. Who knows?
Yes.
So somebody asked that, whether I will not be able to go there. And I am punished. You ask me to go there first. And when I refuse, you can penalize me.
Okay, basically it's the same thing now. Basically
I
now,
will not repeat
yes.
your lordship in my lordship.
Now have any so what are the citations?
Whether your lordship is recorded, noted, my lord, all the
So
citations
those are correct.
in the order. One issue was there, my lord, about the territorial jurisdiction. I placed before lordship two decisions of the independent judgment of the which your lordship is recorded.
Did you give me some
Lord,
judgment?
I give the
Permission to give it?
separately judgments were given. If not available, my lord, from the lordship's order, I will supply another copy.
We went to other benches.
And one issue which they were raising was that there was suppression. Now we will check up from the records, my lord, and the judgment which are not available, we will give the copy.
Because I think how many judgments are
Maybe, my lord, here,
few, I
this
think.
place, we'll just, from the court master, will
So one,
we'll check
two,
up that what judgments are available. One more thing, my lord. They said, my lord, that we filed an appeal after filing the petition, and there was suppression of fact. We placed a decision of the apex court before lordship, my lord, wherein we said
that once the appeal is withdrawn, then there is no suppression of fact. Lordship has quoted the judgment also, that the suppression of fact is not there.
In-house appeal, you mean?
Hello?
In-house appeal.
In-house appeal, no? There also, in that case also, appeal was preferred. And the court said that even if the appeal has been preferred, when the matter comes up, he should be asked whether you want to go by the appeal or whether not to discretion. And in any case, there will be no suppression of fact. That I've also given the judgment, Lord, and your Lordship has also kindly noted the same. Now, one more thing before they start, Lord, because it will again, because my Daniel friend was again not there, now he's there. Lord, the intervener submitting for Lordship, that he will also argue. I will not object to anything, only for your consideration, your Lordship, one paragraph, your Lordship keep in mind, and thereafter, whatever your Lordship please. Please present to the House of Lords. And there are three your Lordship guide. There are three, it starts from leave is given. I think you also got to know.
Para 3, I've got it. It starts with intervention.
The leave is given to statutory bodies. There are three. Let's go to second. Two, my lord. 2 and 3. 3 your lordship, and intervener is however. I was only submitting the lordship making the hearing, but it is not the purpose of the institution of the argument.
Anyway, Supreme Court has made him an intervener.
Yes, yes, you'll also hear it, but anything new which he is saying, you can also make it. I have not, I will never object. We have ever fought, my lord, from this court to division bench to Supreme Court. Now we don't want to fight on that court. Enough fighting was there, my lord. Now nothing doing. Because ultimately it has come back to the same. Impeachment is not allowed. So now intervener letting out the I will stop. I'm highly obliged, my lord.
Yes, who's going to, you are going to, Mr. Chairman?
Judicial has to argue first, my lord.
You can address, no, not an issue. Since you have gone all the way to the Supreme Court to address this court, why not? What is your name, by the way?
Arohi Thalla.
How do you spell it?
Well, it's double A,
Double A,
R-O,
R-O,
H-I,
H-I,
Allah, B-H-A,
L-L-A.
right. I can assure the lordship, I will not interpret a single word because before this also twice, 2 days before also the matter was there, enough fight was there. Today, election day, results are coming. I want to sit right and see that what is the position.
Firstly, my lords,
That's not what I was doing in the lunch.
Well, I mean, the mobile with is there, so we will.
For you, yes.
on the lighter note, my lords, there was no fight.
Fight
There was
means,
only a mismatch of mindsets.
fight means only legal fight in the court. This is not fight personally.
Well, I guess you're well remunerated. Sometimes the fees are inversely proportional to the volume
I bow down to that. I bow down.
and the thickness of the petitions.
Not proportional, but little higher.
Maybe directly proportional, maybe inversely proportional. I don't know. However way you may look at it.
But before making my submission before your lordships.
Yes.
But I'd just like to place the order passed by the Honorable Supreme Court.
Yes, yes.
Because your lordship will find that order. I have moved an application 1519 of 2024.
Yes.
And the penultimate page, my lords, page 101.
101. Yes.
Aye.
Okay. Lordships has that.
Yes, yes.
Because it says the special leave petitions have come up for consideration.
interlocutory application such and such has been filed by respondents number 1 and 2 seeking direction. Having regard to the fact that the special leave petitions have been filed challenging the impugned orders of the High Court, which are interim in nature, we are not inclined to interfere with the same, and hence, without expressing any opinion on the merits of the case, the same are different. Because I'll clarify over here. I had filed 2 special leave petitions. One was impugning the impugned order passed by this board, the interim order of 21st of December, and the continuation of that order of 5th of January. So this was one special leave. The Honorable Court says that these are since interim directions, go back to the High Court and whatever grievance you have, you may say so. However, the learned single bench is requested to decide, then a request is made. Para 3 minutes. It shall be open for all the parties, which includes me also, to raise all contentions as may be legally permissible under law. At this stage, the Honorable Court clarified that the present petitioner shall also be heard as an intent. So, in the facts and circumstances, since they were interim directions, the court initially had stayed the proceeding before it only for the purpose that I should be also given an opportunity to assist with. So therefore, my lord, under the directions of this particular order, I have a right, and your lordship have been gracious enough to hear me on the legal and practical aspects.
No problem. No problem. The only thing is that your rights are not going to be affected.
Yes, that. So, my lords, I'm raising firstly 3 preliminary objections with respect to the very maintainability of the writ petition. And for a moment, if my lords will kindly have this IA compilation again.
Yeah.
At page 50.
Page 50.
Please. This is the order passed by the learned division bench of this honorable court, dismissing my impeachment application. But, my lords, at para 21, kindly see what has been observed. We see no reason as to why the learned single judge would not deal with those issues which, in our view, would form preliminary issues before going into the merits of the charge. As I interpret this observation, that if I am successful as far as the preliminary objections are concerned, your lordships may not go into the exercise of going into the merits of the, because I might be right or wrong, your lordship will decide as far as the subject is. But to my understanding, if the preliminary issues which I raise find favor in your lordships mindset, then in that situation, maybe the issue of going into the merits will not happen. Those 3 preliminary issues are.
Now, what are the preliminary issues? The preliminary issues basically maintainability. That's what.
Maintainability as far as territorial jurisdiction, availability of an alternative remedy which is efficacious in nature.
What remedy is that?
Well, it's the departmental appeal.
Departmental appeal.
Which they prefer also.
If they prefer, then they withdrew.
They withdrew. And I'll show the sequence of events. It's very important. And the third issue, my lords, the most important one, of suppression of a very material fact that you file a departmental appeal.
Yes.
And you don't disclose it to the honorable court. So must kindly mark the date on which the writ petition is preferred. The writ petition is filed on 18/12/2023.
18/5/20.
18/12, December, please.
Yeah.
And the appeal in itself is also filed on that very day.
18/12.
Please. Now there's an argument or a possible explanation to this from the other side, that the writ petition is filed and then the appeal is preferred. In the writ petition, there is no document to show the timing of filing of the appeal. So it can be a converse situation. There's no mention. So kindly have the writ petition was sent by mail. That's not the document,
Kindly have the writ petition.
It was sent by,
by mail. I got the copy that at what time it was sent.
Page 48.
page 40,
48. 48. 48
where is it?
in the writ.
Yes.
Para 38.
Yes,
The averment is there is no other efficacious or alternate remedy. And the remedy sought for by way of the instant writ petition is just proper and adequate ipso grant. So look, firstly, incorrect statement on happen.
Yes.
Then my lords, para 39.
Yes.
That the petitioners have not filed any other petition in any court of law on the same cause of action. So for a moment, my lords, I consider
That is correct.
that's right. I'm only correlating 38 and 39. First, they say that there is no efficacious remedy, and then they say that no other petition in any court of law. And there is no averment that a departmental appeal has been preferred. Now, my lords, the writ petition comes up for hearing for the first time, not on 18th, but on 20th of December. Where, my lords, this honorable court, the learned single judge, issues notice on the writ petition. Whether, my lords, there is any additional affidavit filed by the petition, bringing on record the filing of the department. Because it was his bounden duty to inform the court that subsequent to the filing of the writ petition, I have filed the departmental appeal on 18th itself. Not on 20th, only notices are issued to the respondents. There is no interim protection granted to the writ petition. This order, my lords, is impugned by way of an intra-court appeal the very next day, on 21st. That intra-court appeal is disposed of, virtually allowing the writ. On 21st also,
Inter-court appeal was on
21st, 20th notice is issued
21st
of December.
December.
In fact, if my lords will kindly have the IA
23.
compilation, all the orders are compiled in the IA. For your lordship's convenience. Kindly have page 21 first, at 22. At page 22, madam. On 20th of December, my lord, notice is issued.
Yes.
Now, since there is no interim protection granted, lordship may kindly have there, page 26.
Yes.
The orders in the intra-court appeal, 21/12/2023. My lord, it's an admitted fact now that he says that I have referred the departmental appeal on 18th subsequent to the filing of the writ. On 20th, you don't disclose it to the honorable court. Had you have disclosed, there might be a situation your writ petition have been dismissed, that you go and pursue your alternate remedy. On 21st, when you get an interim protection by the learned division bench, again, you do not disclose. Is that not a suppression? On the basis of suppression, you get an interim order. Then finally, my lord, kindly have page 30. The lordship's order of 5th of January 24. Again, my lords, there is no affidavit that we filed a departmental. My learned friend appearing for BPCL
took that object. But it was the duty of the writ petitioner to inform your lordship, not that. And on page 32, my lord, your lordship granted liberty to BPCL to finalize the tender. But before allotting the work order, your lordship, BPCL did not act upon it because that is the. So it is not that you are telling the court that I have withdrawn the. You have to tell it at the appropriate time. 20th, 21st, 5th of January. And you finally withdraw your appeal. After these interim orders are continued for more than a month, on 14th of February 2020. Now, your lordship will kindly have their rejoinder at page 421
Of the writ petition.
of the writ petition.
Yes.
Because it says that with regard to the statements at para 8, your lordship has para 8?
Yes.
In para 5 of the affidavit in opposition, the deponent state that the appeal was preferred under a mistake of law. I can't. Is this a plausible explanation? You yourself in your writ petition make a categorical statement or note that no other efficacious remedy is available. You avail that remedy. So two parallel remedies are going on being pursued by the writ petitioner and enjoying the interim orders protection granted by the court. Now, in their writ petition itself, at page 381,
Yes.
they have annexed the provision with respect to the departmental.
Yes.
At page 381, 4.2.1.4. After annexing this thing, para 38 goes away.
Para 8 to me.
Para 38 of the writ petition where they say that no application.
No application remedy.
So in their writ petition, they itself are mentioning about the application remedy. And you avail that remedy. So therefore, my lord, if this is not suppression, because I can't put it in any further. And for this, my lord, just one judgment of the Honorable Supreme Court. Your lordship may kindly have page 819. Para 10.
Yes.
It is well settled that the jurisdiction exercised by the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary. And it is imperative that the petitioner approaching the writ court must come with clean hand and put forward all facts before the court without concealing or suppressing it. A litigant is bound to state all facts which are relevant to the litigant. If he withholds some vital or
Sharma, it's in the line of KD Sharma's case.
so therefore, yeah,
Settled law.
it's settled. And
my learned senior agrees that this is the settled legal
Yes,
position.
yes, please.
Now, over here, what they say, my lord, kindly have para 14.
Yes,
Applicable to the facts of my case.
Yes.
It is necessary for us to state that in order to check multiplicity of proceedings pertaining to the same subject matter, and more importantly, to stop the menace of soliciting inconsistent orders through different judicial forums by suppressing material fact, either by remaining silent or by making misleading statements in the pleading, in order to escape the liability of making a false statement. We are of the view that the parties have to disclose the details, what may kindly happen, of all legal proceedings and litigations, either past or present, concerning any part of the subject matter of dispute which is within their knowledge. In case, according to the parties to the dispute, no legal proceedings or court litigations were or are pending, they have to be mandatorily stated so in their pleadings in order to resolve the dispute between parties. Clearly covered. So therefore, my lord, my humble request to your lordship is that since 226 is an equitable and discretionary jurisdiction, on this thought ground itself, my lord, the writ petition should go. The other thing, my lord, on the question of alternative remedy, what has been submitted for your lordships, the highly factual tactics of it. Had there been availing the departmental appeal, the lordship would be having the benefit of having at least the facts in a simpliciter. Therefore, my lord,
simplified and condensed manner.
yes. Whether your lordship will entertain a writ petition under 226, where there are disputed questions of fact is this. They had a remedy, they availed it. They should have gone ahead with that. If agreed, my lord, of course, my lord, the jurisdiction of this honorable court is always open. Just one judgment on the issue of alternate remedy, my lord.
Okay, noted. Yes,
So let's para 4.
Yes.
Before answering the questions, we feel the urge to say a few words on the exercise of writ powers conferred under Article 226 of the Constitution. Having come across certain orders passed by the High Court holding writ petition is not maintainable, merely because the alternative remedy provided by the relevant statutes has not been pursued by the parties desirous of invocation of writ petition. The power to issue prerogative writs under 226 is plenary in nature. Any limitation on the exercise of such power must be traceable in the Constitution itself. Profitable reference in this regard may be made to Article 329 and ordinance of other similarly worded articles in the Constitution. Article 226 does not in terms impose any limitation or restraint on the exercise of power to issue writs. While it is true that the exercise of writ power, despite availability of a remedy under the very statute which has been invoked and has given rise to the action impugned in the writ petition, ought not to be made in a routine manner, yet the mere fact that the petitioner before the High Court in a given case has not pursued the alternative remedy itself available to him cannot mechanically be construed as a ground for dismissal. It is axiomatic that the High Courts have a discretion whether to entertain a writ petition or not, one of the self-imposed restrictions on the exercise of power under 226 that has evolved through judicial precedents is that the High Court could not normally entertain a writ petition where an effective and efficacious alternate remedy is available. At the same time, it must be remembered that mere availability of an alternative remedy of appeal or revision, which the party invoking the jurisdiction of the High Court under 226 has not pursued, would not oust the jurisdiction of the High Court and render a writ petition not maintained. In a long line of decisions, this court has made it clear that availability of an alternative remedy does not operate as an absolute bar to the maintainability of the writ petition, and that the rule which requires a party to pursue the alternate remedy provided by statute is a rule of policy, convenience, and discretion rather than a rule of law. Though elementary, needs to be restated that entertainability and maintainability of a writ petition are distinct concepts. The fine but real distinction between the two ought not to be lost sight. The objection as to maintainability goes to the root of the matter, and if such objection were found to be of substance, the courts would be rendered incapable of even receiving the list for admission. On the other hand, the question of entertainability is entirely with the realm of discretion of the High Court's writ remedy being discretionary. A writ petition, despite being maintainable, may not be entertained by a High Court for very many reasons or relief, could even be refused to the petitioner, despite setting up a sound legal point, if grant of the claim relief would not further public interest. Hence, dismissal of a writ petition by a High Court on the ground that the petitioner has not availed the remedy alternatives without having examining, well, your lordship has skipped it. Then your lordship may have the next page, para 6.
Yes.
At the end of the last century, this court in para 15,
Whirlpool, no?
Whirlpool, the three tests which were laid.
I think one fourth one has been added also subsequently.
So, Millard, over here, the first one is where the writ petition seeks enforcement of any fundamental right. Where there is violation of principle of natural justice, there is no such violation, not feasible. Where the order of proceedings are wholly without. So, Millard, these tests are not fulfilled in the petition. Then, Millard, para 8, that apart we may also usefully refer to such and such decision. What appears on a plain reading of the former decision is that whether a certain item falls within an entry in a sales tax statute raises a pure question of law, and if investigation into facts is unnecessary, the High Court could entertain a writ petition. But my submission was that on a question of law, the lordship can certainly entertain. But where a disputed question, the route of alternative remedy is a better. In this discretion, even though alternate remedy was not available, and unless exercise of discretion is shown to be unreasonable or perverse, this court would not intervene. But there is no such averment that the exercise is perverse. In the later decision, this court found the issue raised by the appellant is to presently legal, requiring determination by the High Court without putting the appellants through the mill of statutory effort. So, my lord, and the last para, my lord, para 9 of this judgment I'll rely upon. Now, reverting to the facts of this appeal, we find that the appellant had claimed before the High Court that the suo motu revisional power could not have been exercised by the revisional authority in view of the existing facts and circumstances, leading to only conclusion that the assessment orders were legally correct and that the final orders impugned in the writ petition were passed upon assuming a jurisdiction which the revisional authority did not possess. In fine, the orders impugned were passed only without jurisdiction. Since a jurisdictional issue was raised by the appellant in the writ petition, questioning the very competence of the revisional authority to exercise suo motu power, being a pure question of, we are of the considered view that the plea raised in the writ petition did deserve a consideration of this. So, had there been a question of law, perhaps, my lords, I would not entitled to maintain this objection for the maintainability of it. It's all factual. And thirdly, my lord, the issue of territorial. So it's under Article 226. Before adducing judgment. The only jurisdictional clause was that the lordship were granted the constitutional mandate to issue writs to respondents within the jurisdiction of your lordship. Subsequently, my lord, amendment came in the book. And the concept of cause of action was also inserted. In the present case, my lord, admittedly, the first part is not there.
Meaning which part?
The first part, my lords, because none of the respondents are within the territorial jurisdiction of this one. All based in Bombay. The tender is floated and opened in Bombay. The office of the official respondent, BPCL, is at Bombay. Works under the tender are to be completed within the territorial jurisdiction of Bombay. Nothing in Assam. And the blacklisting order is also part. So clause 1 goes with. The only clause with respect to cause of action which the writ petitioner can rely upon is 2. Some cause of action. The lordships have time and again held that to establish cause of action, there has to be some averment in the writ. Because I don't find any averment in the writ as to how this honorable court has to approve it. No such averment. My learned senior can clarify at this stage itself. I'll be highly applied. As far as that averment is concerned, the writ petition is very
Government that this court has followed, that this court
has jurisdiction. Firstly, my lords, he has to plead. I'll choke on the judge. Firstly, he has to plead that this honorable court has territorial jurisdiction. And then he has to plead that under what circumstances this court has. None of it. So 2261 on the face of it goes away. And 2262 also. Not clear. Well, face those judgments.
Yes.
Well, this is the judgment of the Honorable Delhi High Court, where the entire law as laid down by the Honorable Supreme Court on jurisdiction has been dismissed. The Lordship may kindly have rather do those comments. But kindly have para 4 for a moment.
Yes.
So it's such and such appearing on behalf of the respondent numbers 2 to 4 refer to the jurisdiction paragraph in writ petition such and such to indicate as to how the petitioner sought to invoke the jurisdiction of this court. In that writ petition, that how the Delhi High Court had jurisdiction has been pleaded. In the present case, my lords, for the sake of repetition, no such pleading in there. Then your lordship will kindly come to para 19.
Yeah.
In the context of the arguments advanced by the counsel for the party, it would be appropriate if the genesis of the High Court's territorial jurisdiction under Article 226 is traced from its inception Article 226 of the Constitution originally read as act. Because I was talking about 2261. So this was the original phraseology under the Constitution. And then, my lords, it says to issue to any person or authority, including in appropriate cases, any government within those territories. So, my lords, BPCL admitted these, right? So therefore, territorial jurisdiction under one bill. Now, on top of that, you don't plead. Then, my lords, kindly come to para 21. The next. The two questions were raised before the Supreme Court in the case of Hajur Singh in the following terms. Para 20. The two main questions which arise therefore are whether the government of India as such can be said to have a location in a particular place, New Delhi, irrespective of the fact that its authority extends over all the states and its officers function throughout India, whether there is any scope for introducing the concept of cause of action as the basis of exercise of jurisdiction. The Supreme Court, in respect of the first question, observed that this brings us to the first question, namely, whether the government of India as such can be said to be located at one place, namely New Delhi. The main argument in this contention is that the government of India is all pervasive and it's functioning throughout the territory of India, and therefore every high court has power to issue a writ against it, as it must be presumed to be located within territorial jurisdiction of all states. This argument, in our opinion, confuses the concept of location of a government with the concept of its function. The government may be functioning all over a state or all over India, but it certainly is not located all over the state or all over India. It is true that the Constitution has not provided that the seat of the government of India will be at New Delhi. That, however, does not mean that the government of India as such has no seat where it is located. It is common knowledge that the seat of government of India is in New Delhi, and the government as such is located in New Delhi. The absence of a provision in the Constitution can make no difference to this fact. We have to see, therefore, is whether the words of Article 226 mean that the person or authority to whom a writ is to be issued has to be a resident in or located within the territories of the High Court issuing the writ. Then below 226 is reproduced over here. And on the next page, I'll read from what has been underlined, beginning from now. Now it is clear that the jurisdiction conferred on the High Court by Article 226 does not depend upon the residence or location of the person applying to it for authority. It depends only on the person or authority against whom a writ is sought being within those limits. So the address of the writ petitioner is under clause 1. It seems to us, therefore, that it is not permissible to read Article 226, the residence or location of the person affected by the order passed in order to determine the jurisdiction. The jurisdiction depends on the person or authority passing the order being within those territories, and the residence or location of the person affected can have no relevance on the question of title. Thus, if a person residing or located in Bombay, for example, is aggrieved by an order passed by an authority located, say, in Calcutta, the forum in which he has to seek relief is not the Bombay High Court, though the order may affect him in Bombay, but the Calcutta High Court, where the authority passing the order is. Look, in our case, the impugned order is passed. So the test is clearly applicable. It would therefore be, in our opinion, to be wrong to introduce in Article 226 the concept of the place where the order passed has effect in order to determine the jurisdiction of the matter. It has been submitted from the other side that we have received the order. This provision is very clear that will not confer jurisdiction. Then below in para 23, I'll only trouble your lordship with the underlined. There can therefore be no escape from the conclusion that these words in Article 226 refer not to the place where the government may be functioning, but only to the place where the person or authority is either resident or is located. So far, therefore, as a natural person is concerned, he is within those territories if he resides there, permanently or temporarily. So far as an authority, other than a government is concerned, is within the territory if its office is located there. So far as a government is concerned, it is within the territory only if its seat is within. Then, my lord, the first question was answered. Kindly come to para 25. Para 25 on the same page.
Yes.
Article 226 as it stands does not refer anywhere to the approval of cause of action and to the jurisdiction of the High Court, depending on the place where the cause of action approved, being within its territorial jurisdiction. Proceedings under Article 226 are not suits. They provide for extraordinary remedies by a special procedure and give powers of correction to the High Court over persons and authority. And these special powers have to be exercised within the limits set for them. These two limitations have already been indicated by us above, and one of them is that the person or authority concerned must be within the territories over the High Court exercises. Then your lordship may kindly have the next page, the underlined para 2. The concept of cause of action cannot, in our opinion, be introduced in Article 226. For by doing so, we shall be doing away with the express provision contained therein, which requires that the person or authority to whom the writ is to be issued should be resident in or located within the territories over which the High Court has jurisdiction. It is true that this may result in some inconvenience to persons residing far away from there, who are aggrieved by some order of the Government of India as such, and that may be a reason for making a suitable constitutional amendment in Article 226. But the argument of inconvenience, in our opinion, cannot affect the plain language of 226, nor can the concept of the place of cause of action be introduced into it. For that would be do away with the two limitations on the part of the High Court contained. Then you will also skip para 26. Kindly have para 27. After the decision in the case of Hajur Singh, there was an amendment. And the amendment, my lords, it says to issue directions, orders, or writs to any government authority or person may also be exercised by any High Court exercising jurisdiction in relation to territory within which the cause of action wholly or in part arise. For the exercise of such power, notwithstanding that the seat of that government
So the concept of cause of action is here.
is here. So, my lords, there are two concepts. The first concept is, my lord, the respondents within your lordship's jurisdiction. That has not been done.
But in the earlier judgment,
Yeah.
the concept of cause of action would not be introduced. That's what you're saying.
Yes. I'm only saying that Hajur Singh's judgment, the first judgment, based upon that judgment, the amendment took place. Because the only singular test at that point of time was that all those authorities within your lordship's jurisdiction can only be issued writs. Meaning thereby, for an example, if we apply the test of subclause 1, which still stands good, your lordships will refrain from issuing directions to BPCL for the simple reason that they are in Bombay. So as far as that test is concerned, my lord, the writ petitioner fails. The second test, my lord, on which he may be able to try to convince your lordship is the concept of cause of action. Now, as I put it earlier, my lord, the entire tender process is involved. Works under the tender are involved. Impugned order passed into. So what is the cause of action within this scope?
He came to say that he manufactures the goods here in.
And to plead cause of action in the writ, you have to plead territorial jurisdiction. Not done.
The pleadings not complete.
That's right. And I'll show from the judgment that that's a mandatory primary requirement that you have to plead. That how the lordship will go to original jurisdiction, a civil suit. applying the principles of section 20 jurisdiction. And that your lordships have held that 20 is paramateria with 226. So you have to plead jurisdiction. It's not there for the asking. But I'll file a petition and your lordship will assume jurisdiction. You have to plead that. And if you don't plead, I have a right in law to make an objection to this. And supplies also, because the entire tender is in common. So, Milord, applying that principle, firstly, Milord, if he is manufacturing some goods over here, and if he is manufacturing some goods, say in Chennai, Milord, whether he can say I have concurrent jurisdiction, both Guwahati and Chennai, and then I can doctrine of election is there, and the dominus litis. Therefore, Milord, cause of action has to be taken in the facts and circumstances of it. So I'll read further. Lordship may kindly come to the next para 29.
29.
Please. Plus, firstly, I'll read para 28. I'm sorry.
Yes.
This amendment introduced the concept of cause of action, which the Supreme Court had earlier refused to read into Article 2261. However, this does not mean that the concept of territorial jurisdiction under 226 was supplanted by what I was arguing. 2261 still remains. The decision of the Supreme Court in Election Commission versus such and Khajur Singh were rendered in the context of 226 and in the absence of any provisions of the nature of 2262. The introduction of 2262, as observed in such and such, widened the width of area in respect of writs issued by different types. In fact, 2262 can be construed as an exception to the limitations mentioned in Election Commission as approved in Khajur Singh. The power conferred on the High Court under 226 could now be as well exercised by any High Court exercising jurisdiction in relation to the territory within such which cause of action in whole or in part arose, and it was no matter that the seat of authority concerned was outside the territorial limits of the jurisdiction of the High Court. This distinction between provisions of 1 and 2 has to be maintained. While 226 empowers a High Court to issue writs to a person, authority, or government within its territorial limits, beholds the questions of where the cause of action arose. 2262 enables the High Courts to issue writs to persons, authorities, or governments located beyond its territorial limits, provided a cause of action arises in whole or in part within the territorial jurisdiction extended to the state. What 2262 has done is to extend the jurisdiction of the High Courts beyond their territories in cases where part of cause of action arises within its territory. Therefore, Article 2262 extends and does not supplant 2261. Then few decisions have been relied upon and says all pertain to Article 2262. The the celebrated judgment of Muslim English of the Constitution and reference to the question of cause of action. It is true, as observed in Kusum Indet, that the decision in Khajur Singh would not be relevant insofar as the argument of cause of action is concerned, inasmuch as Khajur Singh was a decision rendered prior to 15th Amendment. Dr. may kindly mark this. But this does not mean what Khajur Singh has decided in respect of 2261 can be whittled down or ignored. This is a decision of 7 judges of the Supreme Court, and with regard to the provisions of 2261, it is definitive. So Khajur Singh was Milord's constitution meant 7 judges. And that is good law as far as 2261 is concerned. Kusum Ingots and other Milord's ONGC are 2262 with the concept of cause of action. Now, in this judgment, Milord's the learned
So basically, it has to be read together. That's why.
I'm obliged for that. The learned judge in para 29 has very beautifully given an illustration in the form of a table to illustrate the scope of territorial jurisdiction under Article 226. The following table may be referred. Where is the seat of government or authority or residence of person to whom the writ is to be issued? It's considered as place A. And where does the cause of action whole or in part arise? And then they say which court would have it. By virtue of 2261 as well as 2262, A will have it. So, if the writ petition had been filed in Bombay, we were not in a position to raise this. Because the respondent is within the jurisdiction of Bombay. Blacklisting order at Bombay to cause. Then below, where the respondent is again A, cause of action B. Then below, it can be in any of the high courts, A or B. For example, below the respondent is in Bombay in the present case, and it has a branch office over here, and the blacklisting order is passed at court has. How about C? Now, where is the seat of government or residence of person to whom the writ is to be issued? Now, let's P, Guwahati. BPCL. BPCL is not here. And neither the cause of action is available.
Cause of action, where is it?
Bombay.
No, what do you do with this chart? Why does it go to A? Why can't it be B and A?
Below B,
Where is the seat in NC? Where is the seat?
they have taken two criteria. 1,226 that is A. Correct. The other criteria is cause of action 2,262.
Okay, they have done it the opposite way.
That's it. That's it. So therefore, my lords, I could have understood that the official respondents are within the territorial jurisdiction of this honorable court. Answer is no. To apply by way of a departmental appeal in Bombay. The blacklisting order is passed at Bombay. The works under the tender, had it been to be carried under your lordship's territorial jurisdiction, I could have understood. The entire work is to be performed in Bombay. And I just said, my lord, in Hajur Singh, they said the place of residence of the petitioner is not. It might cause some inconvenience, but that cannot be the crime. Then, my lord, para 30.
My lord, if you lordship, I think he's going to take the full day. So I may kindly appeal, but you need to say, they're talking about reading the judgments and judgments. So,
Okay. You don't want to reply.
I will reply. Not today, because he's going to check the full day. He may think that the AI was taking full. How I can, there is no use of. He may read the entire judgment without, you can stop him.
I think he's got, I don't know how long are you going to take?
So I don't know,
Let's-
because
On this, about 10 minutes. And then on the merits minutes from the documents itself, I'll show because that the rectification.
Oh, it's not going to finish today.
first of all, my lord, I strongly object that the intervener is making the argument.
No, on the maintainability,
BPCL has.
you see, the problem is, whatever the objection, the division bench has passed certain observations.
Preliminary party lordship has heard.
And I am bound by the
Well,
division bench observation.
preliminary objections your lordship has heard. But he cannot be allowed to make arguments from very. BPCL has to argue because he is not the person. BPCL has to argue and thereafter if something is left out, like the House of.
Very well, my lord.
He
I
can
was,
submit.
And then let us see,
Because otherwise, my lord, the whole purpose is frustrating, my lord, the intervener. He becomes again the entity party, my lord.
no, no, I have not filed any document.
No, not document.
I'm only relying on your documents. I'm
Your
relying on your
document-
pleadings and
You also
documents.
may see the judgment that he can either support the petitioner or the respondent. Whom he is supporting, respondent has not argued.
So therefore, my lord,
no, he is supporting Mr. Roy.
that's right.
So I have no objection, your lordship may be any question hearing, he has come from Delhi. And your lordship, he is no objection on how I can object. Your lordship. But let him argue.
He has gone all the way to Delhi and back.
So we also may go to Bombay also, we are not given the
Yeah.
same treatment that we come from Guwahati to Bombay.
You don't get the same treatment.
So it's never given. So from Delhi to Guwahati.
What to do, what to do?
No court is small.
No.
I also,
No,
because I
Guwahati to
can't.
Delhi, below the small place is there. People coming from Delhi,
But-
they get special treatment.
No, there is nothing. like that.
My hometown,
Everyone is giving special treatment in this.
No, I have no objection, below, your lordship patiently hearing. And make it with it.
Okay, we'll fix another date for him to give a reply.
Reply. Because
on
whatever
Thursday.
we are- whatever we are,
can it be on Thursday, my lord?
No problem. Which
but the
Thursday?
only adjustment,
After tomorrow.
Yeah, because my lord,
only little adjustment, that some other matters are also there.
No problem.
Accommodation. And I have heard these are three arguments. We will make a noting on merit, whatever.
Correct. after tomorrow,
Well, I'll give reply and I have to find out some judgments also.
correct, you have got to do.
Because
got
I've got the
to-
judgments all, my lord.
Yeah.
I've noted it.
Then they are juniors to burn some midnight.
No, my lord, all notings are there. So we'll be telling you the job, we'll find out. I'm highly obliged.
Lords, then I'll straight away, my lords, not trouble your lordship with the law discussed by the learned judge over here.
The
Different-
maintainability part, I think you have covered.
my lord, only at page, at para 48. The
Para
test-
48
Yes, my lord, the tests which have been laid down
in this same judgment.
in the same,
Para 48.
kindly see, my lords, para 48.
Yes,
On the basis of the above discussion, which after referring to various Supreme
yes,
Court
yes.
judges, it can be safely said that Kusum Ingrid's was definitive with regard to the following. Passing of lordship may skip 1, 2, and 3.
Ah.
Because that is with respect to a legislation. 4, 5, and 6 will be.
Yes.
The question as to whether the court has territorial jurisdiction to entertain a writ petition must be arrived at on the basis of averments made in the petition, the truth or otherwise thereof being in. So, now, my lords, what are the averments made? Now, it's on the basis of averments you have to make in a writ petition. That your lordship will decide that whether this court can issue a probative writ or not. Then, my lord, when a part of the cause of action arises within one or the other high court, it will be for the petitioner to choose his court, provided that cause of action arises. In appropriate cases, well, this would be important. The court may refuse to exercise its discretionary jurisdiction by invoking the doctrine of forum convenience.
Yes.
So, my lords, in
What do you mean by forum convening?
Well, it's in Kusum Ingrid's, I'll pass the judgment to you and the relevant paragraph. Yep.
When did you submit?
Because I
That
have
was
another
in-
copy.
February. I don't remember what happened in February.
Well, it's in Kusum Ingrid's. Kindly have. The last page, para 21.
Yes.
Before that, Malud, a page before Malud, para 16. Just 3 paragraphs I'll read from them.
Yes.
Page 16. The expression cause of action.
No, para 16.
Para 16, my apology. Page 797. In Kusum Ingrid's. Your lordship are referring to Kusum Ingrid's or Delhi High Court? Yeah.
But then that is at Devon Court.
Sorry.
Page 261.
Sorry. Well, it's the penultimate paragraph at page para 30 minutes.
30.
Please, of Kusum Ingrid's 264.
Yes.
Starts with Malad, the heading forum
Yes.
convenience. We must, however, remind ourselves that even if a small part of cause of action arises within the territorial jurisdiction of the High Court, the same by itself may not be considered to be a determinative factor compelling the High Court to decide the matter on its. In appropriate cases, the court may refuse to exercise its jurisdiction.
No, but that is all right. It's a matter of discretion of the court.
So therefore, my lord, the test which has been laid down in Kusum Ingrid's case, that even if a small part of cause of action is arising, still the maintainability of the writ
Can be gone into, but does not mean that it cannot.
it's not an
cannot
absolute,
be-
it's not an absolute test.
Yes.
It is,
There is nothing that there is no bar.
Yeah. It went small parts of for the fact. Over here, there is
So on the other way of looking at it.
Yes.
Is if there is a small, even a small part of the cause of action arises in some other territory, why not?
that's right on that principle. But over here, that small cause of action is also not there. That's what my submission. Then, Manoj, the Delhi High Court judgment which I was referring to, para 55. Para 55, Manoj. Last 3 lines, it says
Yes.
a writ petition has to be arrived at on the basis of the averments made in the petition. Again, the test of petition. So there has to be averments pleadings in the writ petition. If the petition is bereft of those pleadings, then verbally Manoj, jurisdiction cannot be. And the last judgment on jurisdiction.
Yes.
It's over here.
So all these, this order is going to be a very fat order. Thick. Yes. Which para?
Well, it's para 12. Let's firstly kindly see the facts of the case for a minute. That would be important.
How many judgments are you going to rely upon?
This is the last. As I said, Manoj, earlier 10 minutes. Well, it's the first para of the judgment.
Yes.
The appellant is one of multiple respondents in such and such, pending on the file of Sikkim High Court. Separate applications in the said writ petitions were filed by the appellant, seeking its release from the
Para, where are you reading?
Well, is where the judgment begins. Para, it's not numbered.
Leave granted.
Page 793.
Yes, yes,
Leave granted. It starts with leave.
yes, yes.
Then its last 3 lines.
Yes.
Appellant had pleaded in the said application that inter alia a notification issued by it was under challenge in the writ petition, and that if at all such notification could be made a subject matter of challenge, the High Court of Bombay at Goa is the appropriate court where remedy ought to be pursued. According to the appellant, a notification issued under a statute enacted by a state legislation cannot be subjected to judicial scrutiny within the jurisdiction of a high court or a different state. More so, when no cause of action has arisen within the jurisdiction of that. It was further pleaded that since no part of cause of action for the invocation of the writ jurisdiction has arisen within the territorial limits of the High Court, the writ petitions ought not to be proceeded against the appellant. One other fact brought to the notice of the High Court by the appellant was that the same notification was under appellate. That's something different. Then kindly come to Manoj at the bottom of the page, para 6.
Yes.
The short question that arises for a decision on these appeals is whether the High Court was justified in returning the finding that at least a part of the cause of action has arisen within the jurisdiction of this court and premised on such a finding to dismiss the application. Then will kindly come to para 9.
Yes.
For the purpose of a decision on these appeals, the petition averments in the WC may be noted. Well, the averments were made. Over here, there is no averment at all. And then your lordship will kindly come to the next page, para 12. Okay, yes, para 12. In support of territorial jurisdiction of the High Court to entertain and try the writ petition, that is what the petition company has stated. To invoke jurisdiction, this is what has been extracted. That this honorable court has jurisdiction to entertain the writ petition as the cause of action arises in Sikkim only. Both the petitioner and the respondents are located within the territorial jurisdiction of this honorable. In spite of these averments, the Honorable Supreme Court said no jurisdiction to Honorable. Para 13. From the above, it is clear that according to the petitioning company, the cause of action has arisen in Sikkim only, meaning thereby the whole of the cause of action and not part of it. Additionally, it is stated that all the respondents are located within the territorial jurisdiction of the High Court, which is actually incorrect. And we'll kindly skip para 14 and come to 15. This is a case where clause 2, and the petitioner is also relying on clause 2. Article 226 has been invoked by the High Court to clothe it within the jurisdiction to entertain and try the writ petition. The constitutional mandate of clause 2 is that the cause of action referred to therein must at least arise in part within the territories in relation to which the High Court exercises jurisdiction. When writ powers conferred by clause 1 are proposed to be exercised, notwithstanding that the seat of government or authority or residence of the person is not within those territories. The expression cause of action has not been defined in the Constitution. Para 16. The expression cause of action has not been defined in the Constitution. However, the classic definition of cause of action given by Lord Bett in Cook versus Gill, that cause of action means every fact which it would be necessary for the plaintiff to prove, if traversed in order to support his right to the judgment of it. So that cause for the plaintiff to prove. Now he can only prove once he makes an averment in the plea. In absence of such averments, he cannot prove it. Has been accepted by this court in a couple of different. It is axiomatic that without a cause, there cannot be any action. However, in the context of a writ petition, what would constitute such cause of action is the material facts which are imperative for the writ petitioner to plead and prove to obtain the three facts.
So out here, it doesn't have to be a specific averment to the fact that the High Court has the
That's
jurisdiction.
what it says.
No, it is basically the material fact.
No,
With
Kindly-
regard to the
kindly-
question, maybe.
Kindly link it with Kusumingit. Kindly read it again. It is firstly, my lord, the expression what cause of action is
No.
has not been defined in the Constitution. By relying upon a judgment, cause of action means every fact which it would be necessary for the plaintiff to prove. So, my lord, how will a plaintiff prove a fact?
The pleadings have to.
On a question of law, he may not plead. But as far as the fact as to territorial jurisdiction is concerned, it has to be specifically pleaded, held in Kusum Ingots also, followed by the Delhi High Court. I showed that paragraph, the penultimate paragraph. Then 17, determination of the question as to whether the facts pleaded constitute a part of cause of action. Now, it's very specific. Facts pleaded sufficient to attract clause 2 of 226 of the Constitution would necessarily involve an exercise by the High Court to ascertain that facts as pleaded constitute a material, essential, or integral part of the cause of action. In so determining, it is the substance of the matter that is relevant. It therefore follows that the party invoking the writ jurisdiction has to disclose the integral facts pleaded in support of the cause of action, do constitute a cause of action, empowering the High Court to decide the dispute, and that at least a part of the cause of action to move the High Court arose within its duty. Kindly mark it. Such pleaded facts must have a nexus with the subject matter of challenge based on the fair county ground. And then below the penultimate paragraph, para 21. The next page, 790. Even otherwise, what's the para 21?
Yes.
Even otherwise, the High Court was not justified in dismissing the interim application. Assuming that a slender part of cause of action did arise within the state of Sikkim, the concept of foreign convenience is thought to have been considered by them as held. Well, over here, he has not pleaded anything. And the test is, even if a small part of cause of action arises, that has to be looked into, that whether the honorable court will exercise discretionary jurisdiction, which is equitable in nature. And
Now, till it had gone before which high court?
well, it's Sikkim. The notification was of Goa. State of Goa filed applications before the Sikkim High Court for deletion as a party respondent. Those applications were dismissed, carried forward by special. Over here, the impugned order is passed at Bombay. Over here, in Sikkim, the impugned notification was at Goa. The writ petitioners in the Sikkim High Court, they were carrying business in the state of Sikkim. So therefore, they went to the territorial. So as far as these three preliminary objections are concerned, to sum it up, territorial jurisdiction, alternate remedy, and suppression, which is very important. And on merits, would you lordship hear me after BPCL? I'll only assist your lordship from the record, which has been passed.
How long will you take? And more on that.
15, 20 minutes. Because I've curtailed my article.
What is it on merit? What have you got to say on merit?
360, page 369
Huh.
is the basis of their case.
Huh.
Now, what led to 369 has not been shown to you.
Okay.
I just wanted to place those.
Okay. Yes, one let to page, please.
My lords, kindly have. Firstly, my lords, page 216, which I had shown to your lordships earlier also.
Yes.
Now, this is the letter of acceptance dated 23rd of January 23, which is addressed by BPCL to Mukti.
23-1.
23. Now at 217, serial number 3.
Yes.
Estimated value of the fund.
Yes.
Is, my lords, 15 odd crore, which includes GST at the rate 18%. At page 218, clause B.
Yes.
Without adding the tax component, the contract value is 1272 odd. 12 crore 72 lakh 63.
Performance bank guarantee of 3% of basic value.
Yeah.
Of that.
So if you add 18% to this 1272, it comes up to 15. So the basic value is 12. So what has been submitted, that the terms of the policy, made in India policy,
Yeah.
were misinterpreted. I'll take your lordships, kindly have a look to the policy at page 169. There cannot be any interpretation at all. The policy starts at 169, 23rd February 2022. This is the governing policy. The initial policy is of 17, but the 22 policy is governing the present time. And kindly have
Page 169.
169.
Ah.
And then at 171.
Yeah. This
The-
is what policy is this?
Manoj, I'll explain what happens, Manoj. When BPCL comes up with a tender, if there are certain participants who have a minimum percentage exceeding 50% of their product from which they have been finally manufactured, the raw material component is 50% or more made in India, then they are given certain benefits. Like over here in the present case, the writ petitioner was not held. He's class 1 supplier. He was not L1. Because of his certificate which he gave, that the local content of the raw materials which I have used to make the final product is 82 point odd% made in India. On that ground, he was awarded. So it is not that he was L1. This goes to the root of the matter. So therefore, Manoj, what is the definition of local content has been captured in the policy itself at page 170.
So supposing
Yes.
he had given his local content at say 51. He might have been L2, L3. What is it?
Because the certificate given by him is 82. Now, because of that certificate, though he is much lower down in the ladder, he jumps and gets the benefit under the policy. Had he given the correct raw material content of about 51 or so something, then there could have been a possibility that some other person must have. So
That's the we don't.
that we don't know. But then on the basis, because that goes to the root of the matter, from the very stage of inception, because he's
Yeah.
committed a fraud on the tendering authority.
If I give him a wrong local
Right.
content.
Yeah. Now kindly see the definition of local content under 171 at page 171, 2.3.
Two point three.
Local content hereinafter abbreviated to LC means the amount of value added in India, which shall, unless otherwise prescribed by the nodal ministry, be the total value of the item procured. And now Miller's kindly marked it, excluding net domestic indirect taxes. And now the most important aspect, minus the value of imported content in the item, including all customs duties as a proportion of the total value.
Okay, now in a easier way to understand this, just give us an example.
Yes. Now, Miloj, if I am manufacturing a final product,
You're manufacturing that pipe.
and say 4 raw materials are to be utilized for the final product to come. I purchase 2 raw materials within India, and I purchase 2 raw materials which has been done in the present case from a foreign company. Now the purchase of that foreign company will not be included in the local content. Now, the definition is very clear. You can't interpret it. Their interpretation is, okay, though we have taken it from a foreign company, but whatever is the cost and the other materials which have been used,
Cost of what?
cost of making the final product. I'll show from their pleadings itself.
But not the cost of buying them.
So therefore, Miloj, the imported content is barred under the definition. So there cannot be any interpretation. What you have to show is that you have to show from your documents, from your invoices, that these are the raw materials which have been utilized in making of the final product. And these raw materials are originating from India itself. The invoices can be there, which you don't. So therefore, now to take a plea that I was under a misconception as to the interpretation of the definition of local content, this is an after. and your lordship's vast experience, a policy and a definition in such circumstances cannot be. We are not interpreting a statute over. There is a definition of local content which says that imported things which you will take, that cost cannot be, that raw material cost.
So that raw material, the local content material, that has to be manufactured in India.
Procured and manufactured.
Supposing it is procured by some other agency and it tells it to say the petition. What to do? Then
If it is imported, if custom duty is paid, you're out. The moment you pay custom duty,
even if you're the third buyer after it comes into the country.
I'm deeply. I'm sorry. I'm coming on that. Yes, I'm coming. Kindly have paid once in.
Yeah.
Grateful to my investigation. Determination of LC. LC of goods shall be computed on the basis of the cost of domestic components, in goods compared to the whole cost. The criteria for determination of local content cost in the goods shall be as. In the case of direct component materials based on country of origin. In the case of manpower based on INR.
What is INR?
Indian rupee. So therefore, my lord, there cannot be any interpretation with respect to the definition of it's very. So my lord, kindly have their pleadings and the documents which they have. Kindly have page 15 onward, para 8.
Yeah.
That the respondent corporation thereafter issued dispatch.
Just a
there-
minute, just a
That's
minute.
fine.
Para 8.
Para 8 at page 15.
Yeah.
Respondent corporation thereafter issued dispatch clearance by letter dated 18/2/23, and inspection was completed by the respondent corporation appointed attendant. Now, let's kindly have page 282, which is the corresponding document.
Yes.
Look, the first column is with respect to the specifications of the materials to be sold. Then is the purchase order quantity. And
No,
what
there-
is
no, what? The first is
well, it's
the
serial number and then material description.
material description, yes.
Yes.
Then
Then
PO
the third is the purchase order quantity in meters.
Yes.
And then, my lord, what is inspected? There is a variance.
Now, what is this PRV quantity? PRE
Well, it's previous quantity.
meaning?
It says nil because this is the first inspection which takes.
This is the first one.
So if your lordship will kindly see at serial number 1, 389 is the purchase order quantity.
Yes.
And what is inspected is a lesser quantity.
Correct.
And then there is a balance quantity.
Correct.
So now it is not up to me to inspect the entire material which I have placed the order. Me means BPCL. It is only that quantity which they will give BPCL for inspection. Am I clear?
Not exactly.
Because the entire quantity is 389.
Correct. This entire quantity,
Yes.
389 is the entire quantity that has to be taken.
Has to be given by the registrar.
Correct. And so the PREV is the previous quantity is not
Lord, may
required,
omit that. for-
and inspection quantity is only
Now,
250,000.
now what happens is that once the purchase order comes, there is a pre-dispatch inspection which takes by the agent appointed by DPC. Now he inspects that one.
Correct.
Now he can only inspect the number of quantity of what is given to for inspection.
Or maybe he wants to inspect only a portion of it, not everything.
No, that's not.
Okay, that's not the thing.
Yes. Because Manoj, you have to call BPCL. That's the call for inspection.
Okay. So that
Once
is,
you,
so he has to, so he is going to inspect only the amount that is there for him to inspect.
inspect, he cannot inspect anything more. Because under the tender term, the tender is to be completed in a period of 1 year.
So what I was given to understand
Yes.
is that this is the quantity that is required to be supplied. This is the quantity that was inspected without saying that this is the quantity that was there for inspection.
Offered for inspection.
Offered for inspection. And that the dispatch of this much quantity has been made because they have only asked for dispatch of this much quantity.
And it-
Without saying that actually there was no other quantity left for dispatch. Okay.
And this fact can be gone from here.
From where?
In the document itself, it says reference document. From the table 1, it says
Page 22.
page 282 itself,
Yes.
where the table ends below.
Yes.
It says reference documents. In the middle. Serial number 1, reference documents. At page 282 itself. In the middle of the page.
It says reference documents, yes.
Now, if my lord will kindly have 1.2,
Oh, yes.
Mukund Poly Product, third party inspection agency. The name of the agency is given. And then the specification. And then the release note dated 10/2/23. And similarly in 1.3. So what has been offered by the writ petitioner has been inspected by the person.
Just a minute. BCIL, what are you? BBCIL. BPCL, BPCL, BPCL. No IL, there's no IL. Just a minute, page 53. Page 53, yes. Yeah, where are you reading? No, it starts as BPCL has ventured
That's
into.
right. That's
Ah, ah. Will be wasted. So what do you want to show by way of this page 53? What does it imply? So, no, that's okay. So you are saying the reason for inspection is because it is being sent to different locations. That's it.
And therefore, my lord, that page 282, the last column is the balance quantity, which is not given by them.
Okay, so this is where I was not.
That's
given-
the genesis of it.
Okay, so I was under the other impression that you have asked for a certain quantity only, despite say, I was supposed to supply say 100 pipes. They wanted to inspect only 50 pipes. And they wanted they gave me dispatch orders for only 50 pipes. So, on the other hand, your version is that, so I'm supposed to give you 100 pipes. I could show you only 50 for inspection. And accordingly, dispatch could have been made only for that 50 that could be. Okay, so that, that was what I was given to understand. Anyway, that is one way of looking at it. But how do we prove what you are saying is correct? We are saying this 1.2 and 1.3. Uh,
Well, these are the inspection reports.
no, but how do we say? How do you prove that the petitioner had only offered 50 pipes to be inspected out of that 100?
Firstly, on the legal aspect, it is the writ petitioner who invokes the law. So he has to be very clear in his pleading that I offered the entire material. That averment is not there in the. Had there been an averment that on such and such date, I sent an email to the inspecting agency and to BPCA that this is the entire material which is ready for inspection, because he has to raise the call for inspection. Then your lordship may kindly have the next paragraph on the same page, page 15, para 9. This will lead to 360 times 20. All these laws.
Page
Page 15 of the writ petition, para 9.
yes.
My lords, on 22nd of February, my lords, the inspecting agency sends a mail to the petitioner to justify the local content declaration of 82 ordinance. This letter, your lordship will find at page 282.
Page 284.
Please.
Yes.
Well, it says, this is with reference to the subject of the tender has been mentioned over here, wherein you have submitted declaration that local content in the offered product services is 82.36%. Since now the dispatches have been initiated from your side, we request you to submit all the required documents to justify meeting the local content of 82.36 against dispatch. So kindly show the invoices, because you've jumped up the ladder. You've been given preferential treatment because of your declaration. Kindly disclose us those. This letter, my lord, is replied on the next page, para 10. This letter was replied on 22nd of February. And certain invoices, I'll just read it, Milot, from their pleading. That the petitioner firm-wide letter 1/3/2023 replied to the mail dated 22/2/23 with supported documents to show that the petitioner firm was meeting the local content declaration. In the said letter, petitioner stated that the petitioner firm used around 206 MT raw materials procured from local suppliers and rest 64 MT used from imported goods. Now, this fellow's letter is at page 280.
Yes.
The second paragraph over here, it says to complete the same. What should that say?
Yes.
We have used around 206 MT raw material procured from local suppliers. Rest 64 MT used from imported procured. Now, from 288 records are the invoices which have been annexed to support. So, all these invoices are of the year 2022 and 23. Dr. Will just mark this. I'll come why this is important at a subsequent stage. All these invoices are of the year 2022 and 23.
Yes.
Well, then the next paragraph, para 11, at page 16.
Para 11 at page 16.
Yes.
Yes.
That in response to the said letter 1-3 by the petitioner firm, the petitioner firm received a communication dated 3/3/20 from Trackwell. This is the agency which inspects. To provide material test certificates along with batch numbers procured from local suppliers. So what was given earlier was routed by the investigating agency, the testing agency, I'm sorry. And then, my lord, this letter is at page 302 by the inspecting agency.
Yes.
My lord, what I-
302.
302, Annexure 9. Tax bill. Reference to your documents submitted against justification provided by you by trailing mail. Request to provide us the relevant material test certificate along with batch numbers for 206 MT procured from local supplier, that is CK Plus and Microsoft. Yes. Now, look, this was replied. Lordship may skip to this. Lordship may kindly have para 13. Now, since the details which the agency wanted at 302 were not provided, at para 13, at page 17 of the report, white mail dated such and such, the Trackwell asked the petitioner firm to hold all dispatches till local documents were there. So you are put to notice at page 307.
Yes.
At page 307, my lord, the agency kindly have 307. And just where the email starts, my lord, it says kindly hold all dispatches till we verified your local content. That's just below the subject. It says kindly hold all dispatches.
No, 307.
307.
Does it say that?
Annexure 13.
It says we would like to inform you that we have not received.
On the top, my lords, kindly see where from the first line is from Varun Gupta, where the page starts.
Yes.
And where all this ends, there is a subject, my lord. And just below the subject, it says kindly hold all dispatch. The subject says billing and shipping address. And just below,
From Sneha Mazumdar,
no, my lord, it's
Friday, March.
above
3.
that, my lord, there's a
Subject 3, billing and shipping
yes,
address.
just at the bottom of
Kindly
it,
hold it.
kindly hold. And the same mail is sent by the corporation at 308. That kindly hold the dispatch. Now, my lord, after putting them to notice that since you have not complied with our bill, you are put to notice that kindly hold the at para 16 on page 18. Another mail is sent to them on 9th of March, putting them to notice that the local content declaration of 82% is not complying with the policy. And clarification was done. This letter, your lordship will find at page 310.
Yes.
Then your lordship may kindly see there is serial number 1234 over there at 310.
Yes,
Kindly have serial number 3.
yes,
Further, the raw material sourced by Vegeta Plastic Pipe and BK Plastic is imported and was procured from Baroque, Abu Dhabi, UAE. Refer documents enclosed to them.
but then the present petitioner somebody different. He's Mukan Poly product.
That's right. He purchases these
Okay, from this.
from these companies who had imported these materials from UAE.
Okay, so what about the local content of 52%?
That also is an exercise which your lordships can't go into in written. It's a highly disputed question of fact.
Okay. No, but where have you said that the local content is not even 52? Where is your statement? No, you see, once the raw material of the petitioner is an imported material, then the question of local content does not arise.
Well, I'll come to that document.
Yes, so I want some
Yes.
document from their side saying that there's no local content.
The
No, that's a different thing. I'm saying with regard to this tender. With regard to this
well,
tender,
I try to answer that. But
yes,
I'll try. I'm
how
I
long will
understand
you
what you-
take? How long will you take?
lordship. I can continue on.
Huh?
I'll continue on Thursday. Brief
No, how long will you take now? I don't want to adjourn.
Lordships are also sitting for quite some time
Doesn't matter.
because there are few documents which I have to say. Their documents. I'm in your lordship's hands. If your lordship wants, I will continue. Otherwise, I'll come.
No, okay. The long and short of
Yes.
what I'm trying to say is basically now that because of these documents, now he has come down, he has admitted that local content is 52 or whatever. As on now. But now you're trying, by way of this page 310, now you're trying to say that even that is disputed.
That is
Now, that is disputed by you. Where is their finding or their decision with regard to this letter?
Can I put it in a different manner?
Yes.
Subject to your lordship. The initial declaration is of about 82.
Correct?
Now, you are admitting it is 52.
Correct?
So therefore, the initial declaration given to you
Is wrong.
is wrong.
Yes.
Suppression of facts.
Yes.
On this short ground alone, you can be blacklisted.
Okay, there's no. That is one.
One
that
has
is
to see what the show cause.
one is all right.
Yes.
Now I'm going a little further than that. Since you have brought this 310 to my notice, once you have brought it to my notice, now what is the consequence of this letter 310? What has been done by them?
Let's, I can't the answer
You don't
that.
know. That is according to you don't know.
Yes,
You
I
don't.
can't talk about- But what I'm trying to show from this letter is that initially you gave a declaration by way of a certificate of 82.
So in terms of this letter, so it appears that he does not even have that local content of any percentage.
That's,
So that is a different thing.
Yes.
Now,
but
that,
because it goes to
that-
the root of the matter.
that is basically
That goes to the, I'm showing the conduct of a writ petition.
Now, how does it relate to that T69?
Because I'm coming on that.
How long will you take to reach that?
Because it is their documents on which I'm relying. I have not filed any pleadings or documents from my side. Those inspection reports are not on record for reasons best known to them. And then in inspection record, because they say something else. So therefore,
All the. So those material test certificates, were it ever work, they given to, never given. So they have on their own just admit it, basically, after getting cornered, you know.
and what is important, my lords, is that kindly see page 330.
Yes.
Which was shown to your lordship, but partly.
Ah.
This is in reference to above mentioned tender being such and such for supply of such and such. After assessing your requirements from BPCL's interpretation of the bid document, we have come to the conclusion that our earlier submitted declaration of 82.36 local content in the such and such category is not executable.
That is the fact. It's pretty long. You worked very long last night. That's why. But all that time. Otherwise, he worked last night also. He worked it around 8:30. That's the problem. After you all go home, our work is just starting. So the matter is not done. Yes. This letter.
Plus at 313, it
Yes.
says
So we still fall under the local content
It's
is
not
not to more than 50%.
nevertheless, we would still fall under more than 50%. Now, my lord, this was important. Keeping in mind the above, and on the basis of availability of raw material, to meet the class 1 local supplier local content, we will only be able to cater the first call-up PO quantity under the policy. So what was projected before your lordships was that we want to give the entire material. But when BPCL and the agency is asking, kindly produce those documents. And therefore, for that reason, the dispatch is on hold. You're not producing it. And what finally is produced from pages 314 is shocking. The tender is of 2022. And kindly see at page 315, the invoice which has been annexed. The invoice of the raw material is of the year June 2020, 2 years prior to the tender.
Where is that?
Because on 315, the first column, it says,
Customer number.
yeah, that's right, Anup, right? And the second column,
Huh.
5/6/2020.
So,
Similarly,
so this raw material
similarly,
is prior to the,
prior to the tender,
so what is wrong?
looks 2 years prior to the tender. You will only take a raw material if these are goods made to order. Specifications. Why will any party purchase raw materials without an order in their favor?
Maybe he's having a lot of private business.
Then he has to plead all this.
How
On this aspect, Why I'm saying so is that the bona fides of the petitioner are under a scan. You come down on your local content percentage when you are asked to give the entire documentation. These documents would have been given at the first instance also. Why at a later stage? After reminders, after the entire this thing is the dispatch is put on.
How many invoices are here?
Nominal, page 315, 316 again 2020, 317 again 2020, 318 again 2020, 319 2020, 320 again 2020, then 324 3 millions 2019.
Wait, to 315 to page 31,
To page Milord,
320.
will take still
320 is 2020.
and 323 Milord is 2019.
Then I think, what is this test certificate of 2021?
Milord, these are third party. Nothing to do with the.
And the invoice at page 323 is of
323 is of 2019.
19.
So therefore, Milord, 2.5 years before the tender. Because the goods under the tender are specified.
But these are raw materials, he's going to make them from the raw materials.
There is a possibility that he will use it somewhere else, but where?
I don't know. That's
therefore,
not the,
we
that
have
is,
to read
that is
every-
not the issue here.
That is precisely the issue, that he is showing invoices which are 2.5 years prior to the tender.
How does it matter if he shows invoices which are 10 years old?
So that raises the question mark as to,
It raises a suspicion only.
so therefore, Milord,
Suspicion doesn't play the place of a
I'm
proof.
I'm just showing that if these documents were within his domain,
Why didn't he show it earlier?
when you were put to notice,
Anyway, and this is not the test certificate anyway. This is only invoices.
this is the basis. Because you have to show made in India policy from the invoice itself. The invoices which you had put in earlier, those entities,
Then how do you come to 369?
yes, now come to minutes 369. Minutes 369, serial number, then the specifications. Third is the total quantity. Fourth is the initial order given,
First call up.
first call.
What do you mean by first call up?
Well, it's the first order placed,
First order place.
Yeah.
PO, what is PO?
purchase order.
Purchase order?
Yes.
Quantity because okay. So
No.
this is the first
This is the first call.
call up.
The tender has
But
to be
call up has been made by whom?
by BPC.
So here they have not asked for the entire quantity.
No, I'm not saying so. I'm not
They've asked for 38900.
That's right. Now, when this has been called for by BPCA,
They have shown only 25,000.
25, this has been put to inspection. And this has been put to inspection 25, and what has been dispatched is 20. So, and the balance over here in the last is 13 something. Now kindly read below, balance inspection all to be raised from first. So who will raise this call of balance? It is very critical.
So where do you say this? Is there any terms and conditions of the contract or something which shows that the balance inspection call has to be raised by the
Look,
petitioner?
once the BPCA places the entire order, which has to be completed in a period of 1 year. So that leverage is there with the bidder to complete that entire transaction in a period of 1 year. He can do it in parts. The initial order which has been placed from 52 is 38 something. What has been put to inspection is only 25. So the difference between 38 and 25 has to be done good by the writ petitioner. So he has to put BPCL and the agency to notice that kindly come and inspect the remaining material.
Okay.
So this is how 369 and 370 proceed. What has been told to your lordship is that I am ready to dispatch.
So basically what they are trying to, what I can gather is subject to correction. What I've been told is not correct.
That's the gist of it.
So we'll have to see. Anyway, I think, and it's then what else?
And then, my lords, the so-called notice and the blacklisting order, they are in sync with it. The lordship, 1 minute after BPCL, if that point is not covered, only for 5 minutes, I'll fix it.
Let's do it now.
Very well. Thank you.
Otherwise, we'll not have the end of it.
Yes.
The J. Roy will take a long time and then nothing.
Well, it's 367 is the so-called. Yes. 367. Well, that 367.
Yes.
The first paragraph, the sub-para and first.
The first paragraph.
Yes.
Yes.
You participated, the sub-para.
Yes.
You participated in the said tender
Yes.
and submitted declaration towards local content in the offered product as 82.33 and claimed purchase preference as per such and such as class 1 local supply. Based on the bids submitted, Mukund Poly products did not emerge, may kindly mark this,
Yes.
as L1 bidder for any of the lot schedules, but as their quotes qualified the stipulation of being such and such were eligible for purchase preference under Make in India Policy 2017, subject to confirmation for matching the L1 bid for the particular lot schedule. Then it says quantity for all 4 lots, then the amount is mentioned, 15 crores, inclusive of GST, and the specifications are given. Then, as per the requirement of the above policy, you were required to submit declaration duly supported by cost accounting, statutory auditor's certificate towards maintenance of requisite local content in the products supplied under every index. In order to meet the said requirement, that the supplies from you meet the stipulated local content requirement, regular follow-up was done from our end with these emails which I had sent. You, however, initially submitted the same document which was submitted at the bidding stage. When advised to submit the documents on every invoice basis, White email dated 21/3, which I wrote to you lordship, you informed that you earlier submitted declaration of 82.36% and pipe category is not executable. It was further claimed that that the products delivered had a local content of 51.45, and thus you would still fall under the category of class 1 local supplier with local content equal to or more than 50% under the policy. You have further mentioned that on the basis of availability of raw material to meet the stipulated local content requirements for class 1 local supplier, you shall only be able to cater the first call PO quantity of BP. Now, to cater to this, you have to call for inspection. You don't do. And the contract value is something more. You yourself are saying that the initial declaration is wrong. And I cannot execute the contract now.
What more do you want?
He's abandoning the contract. And then, my lord, this action of Messrs. Mukund product is tantamounting to committing breach of contract. And the lordship may kindly see 9.2. It has been quoted. The sanctions may be in the form of writing, warning, financial penalty, and blacklist. So he's put to notice under the TOPA. and the show cause is adjudicated upon, he files a reply, does not ask for a personal hearing. 372 is the blacklist, which is in sync with the show cause. I'm deeply obliged for a very basic hearing.
No choice. Orders have come from the top.
Deeply.
Okay, then you want to, I think you'll want to address the court some other day. Because I think that. Okay, that's right, huh? Mm. With Dr. Appeals for the petitioner. देखिए सर आप senior counsel appears for the petition assisted by Mr. P.K. Bora. Then Mr. J. Roy senior counsel appears for the BPCA assisted by Mr. S.K. Assistant. Mr. K. Gogoi appears for point number. Mr. Arohi Bhalla appears for the interview. Right. He, wait, before that. This is the matter on 11th.
Can it be Thursday subject to the day after? It can be.
Any time you all want. I know you all
Can be finished, Willow, because on merits I've also placed. My learned senior will assist you a lot.
Look, I, it depends solely upon you. If you all want to do it today, tomorrow, tomorrow to no chance.
Very.
This is the matter on, right? Then be right. Mr. Arohi Bhalla, that is counsel for the intervener, has submitted that the writ petition is not maintained on speaker. Firstly, on the issue of territorial jurisdiction. So subsequently, the petitioner had availed of the alternative remedy in filing a appeal before whom? Before the appellate authority,
The departmental appeal.
the departmental appeal. In terms of clause 4.2.14 of the policy for holiday listing, is it?
That's right. Policy positive.
Policy for holiday listing of vendors in BPCM. And thirdly, due to suppression of fact by the petition. So, next up. The counsel for the intervener submit that while the writ petition had been filed on 18/12/2020 against the impugned blacklisting order issued on
8th of December
8th of December 2023. The petitioner had also simultaneously filed a departmental appeal on the same day. So, however, there is no whisper of the fact of filing the appeal by the petitioner in his writ petition. He further submits that while the writ petition, present writ petition has been listed on 20/12/23, the petitioner should have informed this court that an appeal has been preferred 2 days earlier, that is on 18/12/23. However, the petitioner did not do the same. So, as the interim prayer prayed for by the petitioner before the learned fingers, before this court was not granted at the on 20/12/2030. The petitioner preferred a writ appeal being WA number
471
471 of
of
2023, which was listed on 21/12/2020. The division bench of the court in its order dated 21/12/2020 allowed the petitioner to participate in all tender notices by the order dated 21/12/2020. He submits that even before the division bench, no averment had been made by the petitioner that he had filed an appeal by availing the alternative remedy available under clause, no, that clause, whatever, 4.2.1. When the matter was listed again before this court, on 5/1/2024, the issue of the petitioner filing an appeal was raised for the first time by the counsel for the BPCL. Thereafter, the appeal was withdrawn by the petitioner on 14/2/2020. The petitioner's counsel submits that the petitioner, while filing the writ petition in para 38 of the writ petition, had stated that there was no other efficacious and/or alternative remedy available to the petitioner? Yeah. Further, the petitioner in para 8 of the affidavit in reply, which was filed on 23/2/2024, stated that the appeal filed by him, the departmental appeal filed by him, was under a mistake of law. Which was withdrawn by letter dated 14/2/2024 on legal advice received. The petitioner's counsel submit that not only has the petitioner suppressed facts before this court, despite there being an alternative remedy available, the petitioner. Now, the writ petition has to be dismissed for not being maintained as the Bombay High Court as the territorial jurisdiction to try the present. He submits that the respondents are all located in Bombay, in Mumbai, and the tender was floated in Mumbai. The supply of pipes is to be done to Mumbai. To Mumbai or Maharashtra or what? All over India. Where? Mumbai. Hey, yes, Mr. Roy. The pipes have to be supplied where? Are to be supplied, page 54 of the are to be supplied to various places,
Finish page 53.
various places, excluding the state of Assam. Further, the blacklisting order has been issued in Mumbai. Accordingly, submit that the next the petitioner's counsel, he also the counsel for the intervener submit that the petitioner has not made any averment with regard to this court having the territorial jurisdiction over the present subject matter in it. And the fact that the cause of action has arisen within the territorial jurisdiction of the they accordingly submit that as the petitioner has not taken any plea with regard to the Yeah, with regard to this court having any jurisdiction over the subject matter in it by not pleading, by not making any pleading with respect to Article 226 bracket 1 and 226 bracket 2 of the Constitution. Of the which petition is dismissed or not being made, has not been made. To stop. In support of his Nestara, in support of his submission that the that this court lacks territorial jurisdiction to consider to consider the subject matter in it. He has relied upon the judgment of the Delhi High Court in the case of 2007 SCC online DEL 2094. That, that number 2 you write 2004 6 SCC 254. Then next 2023 7 SCC 791. Then you write next para in support of the submission that this court does not exercise its discretion in this present case in view of an efficacious alternative remedy being available and which had also been exercised by him. He relies upon the judgment of the Supreme Court in the case of 2023 SCC online SC 95. He also submits that as the petitioner has played hide and seek with facts by suppressing the fact that he had filed an appeal under clause 12. He submits that the writ petition should be dismissed in terms of the judgment of the Supreme Court is 2022 12 SCC 815. Okay, next. The fact that the submission of X, submission of X, is to the effect that you can sit down both. Why is sending like in pursuant to the NIT dated 16/8/22, the petitioner had been issued a letter of acceptance dated 23/1/23 by the BPCL. Where is? Huh? Okay, NIT dated? 25/7/20. Wherein it was specifically provided in clause 1. Clause 1 in the chart also it is there. Clause 1. And 3. Of the said letter, that the total contract value of the tender was rupees 15,01,70,715, including GST at the rate of 18%. Further, clause 6 bracket, no, clause 6 capital B of the said letter of acceptance dated 23/1/23 was to the effect that the basic value of the contract was rupees 12,72,63,317.80. This is this is clear from the contents of clause 6B, which states as follows. Page 218. Next. The further submission of Mr. X of X is that the petitioner has misinterpreted the policy to provide purchase preference bracket linked with local content bracket close bracket PPLC. In as much as the definition of local content as provided in clause 2.3 of the PPLC provides that the amount of value added in India, which shall, unless otherwise prescribed by the nodal ministry, be the total value of the item procured, bracket excluding net domestic indirect taxes, bracket close, minus the value of imported content in the item, bracket including all such is at page 171. Further, clause 6 of the PPLC provides the determination of the local content, which is enumerated in clause 6.1 to 6.1.3. Correct? Page 176. Okay. Acha, where is the class 1 and 2?
Page 170. Page 170. 2.5 Maloj is class one.
Clause 2.5 of the PPLC. You put this earlier than this. Like last I thought. Provides the definition of class 1 local supplier. Class 1 and class 1 Roman 1, huh? And class 2 local supplier. Depending upon the local content of the manufactured goods. Is it? Of the manufactured goods and services. Goods or services. Which is as follows, huh? Page 171. 2.5. Okay. Next. I think you call that other thing. Anupam. Because it takes too much time. No? Huh? How much is it? Next para. The no, then there's para. Track Ebel. TRACTEBEL. They are not a party here, I think. No.
Not been implemented.
Who are they?
But this is the inspecting agency appointed by
By Trackbell Engineering Private Limited, which is the inspecting agency appointed by the BPCL for what? For testing, for carrying out inspection uh, with regard to various aspects of the contract, including the local content of the materials to be supplied. Issued a dispatch clearance note dated 18/2/23 to the petitioner. No, dated, wait, dated. There are 2 days.
18.2 is the first part. At page 8.
Ah.
Para 8, page 15.
And then, no, you come to page 282.
282.
You see, there are 2 dates. There are 2 dates. The one on the top, one on the bottom. One is 18/2, one is 23/1.
Well, I think the 23/1/23.
That is the correct one. But then how can it be? How can they?
LOA.
Okay. Okay, so it'll be 18 to 23, 18 to 23 to the petitioner. Requiring the petitioner to dispatch item. The chart made by Factwell Engineering Private Limited dated 18 to 2023 is as follows. No, just take it. Page 282. Page 282. The chart shows that the quantity required for supply for dispatch for 32 mm pipe. What was it? 30, no, is it for 3.0 mm pipe? Is it 32 mm pipe was 389,000 meters. Full stop. For 5 pipe, it was 111,000. Full stop. For 8.2 pipe, it was 45,000, and 11.4 pipe, it was 57,000. Full stop. However, the
5.8 mm.
Huh?
It's 63 mm. The second serial,
second is 63 mm.
63, then 90, and then
Oh,
120.
okay. So it'll be 32 will be first,
That's right.
then it'll be 63 then 90 then 125 So there has been a wrong typographical error out here. Because it shows that is after this 5.8. No. It appears that there is a typographical error in the placing of the Is it? No. Don't say that. Don't say that. Don't say it appears. Full stop. However, the quantity inspected is lesser than the quantity to be dispatched. It is the stand of the respondent that it is the responsibility of the petitioner / supplier to make available the required pipe for inspection. And it is not the case of the PPCL authority inspecting a lesser quantity of of pipe. Then what is required? Then what was required? They submit. The respondent submit that when the quantity required for dispatch has been mentioned, it is the duty of the supplier to make available the said quantity for inspection. However, the petitioner hearing could not make available the quantity required for inspection of the BPCL. Correct? If I don't write all this, I'll forget all this. Next. The counsel for the respondent for the subject that oh yeah. But how long will it take? 1 hour. Only. Very fast. For the submit step, there is no averment made by the petitioner in his pleading that he had offered for inspection the entire quantity of material of pipes to be supplied by. The respondent's further case is that despite the Trackbell Engineering Limited requiring the petitioner to submit all documents to justify meeting the local content of their pipe at 82.36%. The petitioner did not supply the required document to Trackbell Engineering Limited. Instead, the petitioners have annexed various invoices for various invoices. What is this? Invoices of what?
Of the raw material.
Of the raw materials required for manufacturing pipe pertaining to the year 2019, 20 and 21.
Initially, they had supplied, they'd given the invoices for 22, 23. When they were put to notice that still we are not satisfied. Then
There is nothing.
yes, I'm just,
I cannot put everything.
no, I'm just.
The petitioner was thereafter directed to put on hold all dispatches to be made with respect to the supply of pipe till verification of the local content documents were made by Trackbell Engineering Limited. Only by Trackbell or by the BPCL also? And by the BPCL. By emails dated 3/3/23 and 9/3/23. seized by whom?
Because that's my, that's it.
And the other one is time seized by. Yes. Subsequent to the above. Fact. Comma. The petitioner submitted a letter dated 21/3/23 to BPCL stating that their earlier submitted declaration of 82.36 local content in the pipe category was not executable. Nevertheless, as they still fell under the category of class 1 supplier with local content of the pipe equal to more than 50%. Comma. They could be able to get a ACATR, cater to the supply of the first call-up PO quantity under the PPLC policy. So the said letter dated 21/3/26. The contents of the said letter dated 21/3/26 is reproduced herein below as follows. Page 316. Okay. The fact that the petitioner had submitted its tender in person to the tender notice dated, NIT dated again, Mr. Roy, tender notice dated.
Sixteen, 8/20. That's.
Dated so 25/7/22. बरोबर है पता क्या है? By earlier making a declaration that the local content of his polythene bracket MDPE that was pipe was 82.36%, and thereafter changing the local content to equal to or more than 50%. No, there's one thing. Uh, uh, implies that the petitioner has not been faithful, has not been fair. And has suppressed facts. Then where the show cause notice? How many show cause notice there? 330. How many show cause notice? One only. One. Good stuff. Yes, right. Thereafter the show cause notice dated 21/7/26 was issued to the petition stating that he was liable to be blacklisted. The petitioner subsequently, the petitioner made a reply to the show cause notice by letter dated 31/7/2020. And thereafter, the ensuing blacklisting order was issued on
Page 12.
Huh?
Page 12,
8/12/22.
23, 37.
That's all. I'll tell the facts so that I don't have to go through everything. Huh? No, no. Huh? (27 to 24). What do you do? For that time. What you do is you take out that print copy and just make a correction and then you give it to me on the next day. So that you see, make a correction with paper, pen, with pencil, pen better. So that this will not be in the file. This for me. If you